While suspension without stopper, without anything, dismissed. The foresters. So let it be listed sometime. Your Lordship allowed the memo on 10/9. Please give. May kindly be taken up. I mean, listed in the little top of the so that
Petitioner in custody since 2021.
Press added. My lord, pardon to make a criminal appeal for bail. This matter is very urgent. Kindly taken up to 28. Criminal appeal matter. What's on JCR?
yes,
JCR, jail criminal assessment.
for bail.
Sir.
Lordship, criminal appeal. I forbid Lordship here on bail.
Lordship, mention for intent bail.
My lord, I may play item number 13, my lord. I want to type, my lord.
Yes. Number 13.
My lord.
So,
Because after the file the affidavit, my lord, we have to file an objection on that for one time.
let the matter reaches. Yes.
Lord, with permission, my lord. Item 26, there was a direction from my lord to file the counter affidavit by the bank. Bank has not filed the counter affidavit, and the matter is posted today. Is item 26, my lord.
What do you want?
My lord, because they
You
will.
are for the bank.
I am for the petitioner, my lord.
Yes.
They will file the counter. We will file the rejoinder. There was a direction from the my lord. I had order dated 27th October 2020.
He is present now from the side of the bank. So let him come and yes.
Pardon to mention item 24. On behalf of Mr. Udgara, and taken on this to judge. That's some difficulty.
24.
My lord.
No, the petitioner counsel is not here. So make a mention when the counsel is there. Otherwise, we will take it in its own time. Let's come.
Supplementary daily. First up, item number 17.
Lordship, kindly see the last order dated 14/11/2024. But your Lordship directed the personal reference along with the pursuant to your Lordship's direction. In fact, that amount 13 lakhs and 50,000 rupees initially was deposited with the auction purchaser. Lordship directed to refund that amount. Earlier we said that because of the pendency of this matter, lot of difficulties are there. Not he has come with the already general manager. Malad? General manager. General manager he already appeared, Malad. Sometime. I mean, bank draft already say khali difficulties tikke. That is why Lordship play very small player, Malad. Yes. Bank draft 13 lakhs and 50,000 already deposited. What is regarding that 18% interest?
No, have you? It must be given to the petitioner. Is he present here today?
No, petitioner now.
You have brought it is in the name of the petitioner.
Again, name of the
you want to give it today.
No, I mean research it. No,
the original is there with you.
I mean,
Rao. You have to.
Apana. Rao, but there appears to be a gap which is not filling up.
No, that 18%
Yes,
interest.
like the paid the direction is to pay 1350. That is correct. 18%
Yes, last time
there is no neither.
So what he is giving the principal amount for 18%?
But I filed IA established the paragraph 5 because since 2008.
Please hand over the first the bank draft.
Pass on that. Okay. No,
keep it.
Rao difficulties, my lord. Since
just a minute.
I'm sorry. Sorry.
What is the name of the bank manager, general manager?
Upon God.
Prabhu Prasad Chaudhary.
Prabhu Prasad. Prabhu Prasad?
Chaudhary.
You are the general manager.
Yes. Okay.
Mr. Mishra, where is Mr. Rao?
Rao is absent.
He is on the call.
There's got some personal difficulty. He is absent today.
Sorry.
No, it's all right then.
I had interested it.
No, it's all right. It's true. Yeah.
And that is, in addition to this 18% interest, there is
No, we know.
a huge amount of further demand also. Knowing food.
As for the order dated 14/11/2025, Mr. Prabhu Prasad Chaudhary, General Manager, Orissa State Financial Corporation, is present, and he has produced before us a demand draft of rupees 13,50,000 a year लिखियो bearing numbers 101 number टा भी देखी लो, dated भी लिखी दो 21/11/2025 in the name of the petitioner Banmali Mishra. The demand draft is handed over to Mr. H.S. Mishra in court. The photocopy of the draft. Please, Mr. Mishra just make an endorsement. Mr. Mishra pointed out that in that order dated 14/11/2025, there was a direction that the draft amount of rupees 13,50,000 with interest at the rate of 18% is to be deposited. However, the interest part has not been deposited by the general manager OSFC. Yes, what is your submission on that?
Well, I felt that is a violation of the order of the law.
Yes.
But in my IA LRC candidate, yesterday I felt that I number is also there 21247 of
Have you given a
2025.
copy to Mr. Mishra?
No. A copy.
Give
But
a
a
copy.
copy. What's it?
Give a copy, let him go through it. You can take up day after tomorrow.
Sir.
What you have stated in that I
Sir, खाली चाहूँछु हमें उधर little prayer जे reduction of the 18% ଅଛି ମୁଁ waive କରିବା ପାଇଁ ଚାହୁଁନି କେବଳ କମେଇବା ପାଇଁ ଚାହୁଁଛି କାହିଁକି ଆମର ବ୍ୟାଙ୍କ ରୁ ବି 6% interest
just a minute.
because it's a public money 4 and 5 is relevant.
An interim application has been filed by the OSFC, which is registered as IN number 21247 of 2025, in which prayer has been made to modify the order dated 14/11/2025 for reduction of the interest rate. And in allowing the corporation to take further step for payment of the interest petition. The Prabhu Prasad Chaudhary, the General Manager OSFC, has shown affidavit to the interim application. Copy of the interim application has been served on Mr. H.S. Mishra in court today, who seeks some time to go through the same and file his response.
I will also file if you also will see the prayer. I have prayed for damages and expenditure along with the interest.
It's Mr. Mishra.
I will file an IA for damages and expenditure also in addition to the
Mr. Mishra, whatever you want to file, whether we will take up this matter day after tomorrow or next week.
Next week.
So this is
Because they have to pay crores of rupees, not that only the 80% cover my amount.
part of December.
Since 2011, he is in possession of that land. Also, he is earning money out of that land.
Both
No,
Amba,
Just
both
a
consume.
minute.
Yes, sir.
We are not considering today. We
He is
are
earning
just
money out of that land.
referring this matter to 3rd of December 2025. The personal appearance of the general manager is dispensed with for the time being. Hello?
What is the rate of interest you charge on default?
Exactly.
What is the rate of interest you charge on default?
On default normally मला केते हम करछे बार default ले केते
As per the agreement, sir.
What is the agreement? Standard agreement.
For different loans, different rates, different times. Normally, it be the interest plus 2% we charge. So it varies from time to
Same
time.
interest.
that to मला
It comes always more than 18%. Always more than 18%.
No, since a lot, she was asking, Lord, what happened since
The-
2011?
On the
It
next
is
day,
still in possession of that land also.
on the next day, the London Council appearing for the OSFC shall obtain documentary evidence that how much interest the OSFC charging from the loan for default in payment of the amount in time. Yes.
Item 1.
Man, the only defect was copy was not served as to the Learned Union of India. That has been duly served.
Okay, Mr. Manager and Council have for the petitioner submitted that as per order dated 24/9/2025, he has already invoked his effects as pointed out by the staff. So, your accountability. So Siddharth Center Mahapatra and Senior Panel Council files name of appearance for the Union of India, which is taken on record. Yes, what is this matter?
Man, well, the petition is challenging the order passed by the Learned Central Administrative Tribunal Qatar, wherein the order of removal was affirmed by the Learned Central Administrative Tribunal Qatar Lordship. Which is
You were the applicant before the tribunal.
minor.
So what was your prayer?
Lordship there. There Lordship was
the order dated?
order of removal Lordship.
Where is your original application? And they must have also filed the counter affidavit as it appears. Have you filed the pleadings, entire pleadings before the, because we insist on that filing so as to see that
We pass a general order also.
Man,
In these kind of cases, you have to file the pleadings up to the tribunal, entire pleadings of the tribunal.
man.
so
No,
if you
man.
are,
Lordship, that I have not filed.
we
Lordship,
can take up this matter day after tomorrow, you file it.
Lordship, give me some more time, Lordship.
The petition copy must be available with you and the
No, no,
counter, rejoinder, whatever it may be.
Lordship, those copies were not with me.
All right, so tell us a date.
Lordship, can it be taken midweek of December, Lordship? I need some time because
So 15th of December.
my
All right. Mr. Patnaik and Council sits for an agreement to produce the other readings taken before the Learned Central Administrative Tribunal Qatar bench cutter in the OA numbers one so.
By the way, how have you drafted the writ petition without reading the pleadings?
Lordship, the copy of the judgment and other relevant document that
You should you read pleadings.
You see, that is very necessary. Once readings are very much necessary. What was the your stand and what was the reply given, and then your rejoinder if any filed, and what is the finding. So these are and law. So these are all should be.
Unless you
very
read
clear.
all these things, you
Well,
should
the
Cannot
difficulty
point out the what is
draft,
the fault lies there.
while
Suppose-
drafting you must read that.
the difficulty was order was passed in the year 2023.
Whatever.
The petitioner came to just recently, madam.
No, it's all right, but it's a fundamental thing that it should be kept in mind that because if you have not taken factual aspects, suppose something has not been stated, they have not got any opportunity to have their say. Now, legal point is different, but you cannot take it for the past instance here.
Dangerous.
So, all right, take next.
Item 2.
And challenging the order of learned tribunal, it was 9/10/2025, Annex 13, page 173.
Your prayer is that,
Pardon?
your prayer is to pass 1, 3, 8, 9, and 13.
Yes, my lord.
Now you are saying that only 13 to be passed.
My lord,
So
what
what is the prayer here?
prayer here is, my lord,
No, no, in the original application, what is your prayer? Where is that original application?
That also you have not filed. Same problem you have not filed.
And
OA copy, nothing is filed.
what copy files, my lord?
Fine.
where is that?
Yes, your lordship. Page
Page 66, my lord.
Page number?
666.
Acha. Now let us come to that relief sought for.
Yes, sir.
Paragraph number maybe 8. Okay, yes, 8. What was your prayer? Was the charge sheet dated 26/2/2018 issued by against the appellant.
My lord.
Inquiry report so and so, passed by so and so, punishment order so and subsequent order so on. So all these documents you have filed.
Yes,
This charge sheet is annexure 3.
that's it.
Inquiry report is annexure.
An inquiry report I have not.
Find it where? No. Then what about the punishment order?
Annex 8, my lord.
Annexure 8. And about that subsequent order 3-1 that you have filed. That is the appellate authority's order.
My lord.
So that inquiry report you are having with you.
Not at present. I have.
You obtain that and file. The writ petition has been filed by the petitioner Manas Ranjan Das inter alia to quash the order of the Land Central Administrative Tribunal Cutter Bench Cutter passed in OA number 260/0045 of 2020, dated 9/10/2025, in dismissing the original application. From the copy of the original application annexed to the writ petition as annexure 10, we found that the petitioner had made the following prayer before the London Central Administrative Tribunal. Quote paragraph Roman 1, the relief sought for the chief. Page number 76. Though the Land Council for the petitioner has annexed the charge sheet dated 26/2/2018, punishment order dated 23/9/2020, passed by the respondent number 4 tag, वर्तमान opposite party number kete. Where is the respondent number 4?
4, my lord.
Respondent number 4.
My lord.
Opposite party number 4. And order of the appellate authority dated 3/1/2022, which has been annexed as annexure 3, annexure 8 and annexure 9 respectively to the writ petition. But the inquiry report dated 12/8/2020, which was passed by respondent number 5 here, opposite party number 5. Opposite party number 5 has not been annexed to the writ petition. Learned counsel for the petitioner seeks some time to file the said report. आज platform list this matter के भी रखो.
2 of December.
First
2 of December.
week of December. So it will come on 3rd of December.
My lord.
On 3rd of December 2025. Have you filed your appearance memo?
No, your lordship.
So
We'll
who
file it in
will
the court.
reflect?
We are filing today.
Today, your
कहाँ नहा reflect करियो?
Along with me, Mr. Milan.
Milan Kumar, your lordship.
Milan Kumar.
Yes, sir.
And your
CGC, your lordship.
CGC.
Yes.
Mr. Party along with Mr. Milan Kumar.
Yes, sir.
Recently found leaking consently on this present. Yes, next.
Ready.
Item 3.
May I please, Your Lordship. Under the petition is here to challenge the order passed by the Honorable Tribunal under Annexure 4, passed by Honorable Tribunal in way number 616/2019 at page 108, my lord. The case of the petitioner on 108, by which the Honorable Tribunal dismissed the original application of the applicant.
What was your challenge before the in the OA?
And the order of passed by disciplinary authority for punishment, which was a punishment of recovery of rupees 50,000 as a subsidiary offender. I challenge the order of punishment of authority, as well as the order of the appellate authority, my lord.
Only the imposition of the fine was there.
Cost recovery.
For recovery of
As a subsidiary offender, I was charged under Rule 16, my lord.
Yeah.
And the Honorable Tribunal, referring the judgment of Honorable Supreme Court, dismissed my OA without considering my application and grounds stated in the original application. And my main ground was that before Lordship, you have to kindly see Annexure 1, the original application I filed.
Why? What is the allegation against you?
That I just supervisory lapses.
Yes.
Due to supervisory lapses, some GDS BPM committed a fraud. And you Lordship kindly see.
What were you?
I'm an overseer. And charge sheet is at page. Lordship kindly see charge sheet.
Why yes mails me?
Overseer mail.
Overseer mails. Anandapur subdivision.
Item 50, my lord. Charge sheet.
50.
May I submit one thing, my lord?
Yes, sir.
This is a case where they prefer the appeal, but against the appeal they prefer to revision. There is alternate remedies available. Neither it was brought to the notice of the Learned Tribunal either from our side or their side. There is an existing provision in the law that if anybody lost the appeal, against the appeal they prefer review.
That points at the before the original application.
No, original application order against the 30 question, na?
Now court can, I am just highlighting that there is a forum which should be exhausted.
It should go. It should have been against the appellate authority's order. It should have been referred to revisional authority.
Yes.
The statute says.
That
the rule says.
But against the appellate authority's order, they have gone to the
tribunal place. It was not pointed out. You lost a forum.
That is not a point was raised by the tribunal, by the respondent before the CAT, before the Central Administrative Tribunal, that I am not exhausted the revision.
That's what he said. That he could not point out, not you.
Rule 20. I
filed the rules. Let us see that rule and prescribe that you are to the revisional authority.
Only Rule 27 I have exhausted, and Rule 29, my lord,
Mr. Paddy, which rule says about this aspect to approach the revisional authority?
But, I'm sorry, I could not put this because I just
Rule
not remember.
Rule 29. Rule 29.
Rule 29, right.
But that one was not
just
raised before the tribunal.
Revision. It is CCA rule.
Rule 1965.
Twenty के तो पहले
29. 29.
Page number
Again, 186.
127.
You don't know.
29. Right.
Yeah, which is that notwithstanding anything, which is that provision?
So Rule 29 of the CCA rule.
Yeah.
Your Lordship, a revision, notwithstanding anything contained in this rule, the president or the controller or auditor general, in case of government servant serving in the Indian Audit and Accounts Department or the member Personal Post Service Board in respect of a government servant serving is under the Postal Service Board and advisor the Human Resources Development Department of Telecommunication in case of government servant serving in under Telecommunication Board or the head of the department directly under the central government, the appellate authority, next to any other authority, may at any time either on his own motion or otherwise. Let me kindly see. In fact, that 29 is always invoked by the main authority while the punishment is inadequate. It is not a mandatory provision, but here the revisioning authority may invoke this judicial while the punishment is.
No, it is either on his own motion or otherwise means it can be hesitated by. So not that it is only
Modified.
Call for the record of inquiry.
And the power has been given that it can be modified, even set aside the order.
Pass on the road.
But the fair payment, my lord.
It's wide power is given.
Wait.
Why don't you?
But the fair payment now we have come.
You have already availed one.
So now I don't have any other option other than approaching your lordship, because the respondent did not take that point. Didn't raise that point.
Once we, if the Mr. Paddy's contention raised, Mr. Paddy, then this order, what you say, this order is to be set aside, this tribunal's order, and he will be given an opportunity to approach the revisional authority. All these things will do. And moreover, you yourself say that this point has not been raised. So before
may I pray,
tribunal,
lordship may keep it next week.
way is the year 2019. So
Yes.
it took 6 years to decide the matter there before the tribunal, and after 6 years, again, if we remand the matter for this purpose, then it will. Why not we examine all these things here?
Yes, that is also. And lordship may issue notice in this regard with given.
Yes. What is your grounds?
The documents which ought to have been supplied by the authority was not supplied, my lord. The lordship will find that as per the instruction of the.
What is your ground? Let us see that way. What grounds you have taken? Which paragraph? Which are the grounds?
Page 34. And paragraph 5. That it will be evident from Annex A by 2 that while requesting for supply of the document, the applicant has explained in detail the reason for asking such a document and requested the concerned superintendent of post not to punish him, as he has apparently not guilty of any charges. That unfortunately, without supplying the document as requested by the applicant by the Annex A by 2, and ignoring the fact that the charge sheet on the Annex A by 1 was lacking material particular which could not have been answered by any prudent man. The response 3, for the reason unknown, ignoring the genuine grievance of the applicant, passed the final order. Dated 6/12/2018.
Okay, what is the response of the opposite party to your this averment made in paragraph number
But
5 and
that
6?
remains, your lordship kindly
Come to the counter.
before that, your lordship
ଦେଖନ୍ତୁ ଆପଣ ଗୋଟେ ପଏଣ୍ଟ ନେଲେ ତାର କଣ ସେମାନେ ରିପ୍ଲାଏ କଣ
I guess your lordship kindly straightway, your lordship kindly see the order itself at page
please
56.
come to the parawise comments ମତେ ଦେଇଛନ୍ତି ପରା in the counter affidavit page number 88 ରେ 80 ଏଟା କେତେ number paragraph ସେଟା ଥିଲା
ଆଜ୍ଞା
where paragraph 5 where paragraph କେତେ ଥିଲା 4.5 ନା କେତେ
5 ଥିଲା
4.5 तो 4.5 ର ରିପ୍ଲାଏ ଟା ଆସିଛି
Para 6.
para
Page
right,
number 88.
88 question
Page 80.
para 6 ରେ ଅଛି
ପଢନ୍ତୁ
that in response to para 4.5 of the OA, it is humbly submitted that the applicant was given reasonable opportunity to defend the charges and accordingly he was allowed to peruse the documents related to the charges and accordingly the rule 16 case was finalized.
so that is
They have come with the case that they had allowed me to peruse the documents.
so have you filed any rejoinder?
Yes, my lord.
What is your reply on this particular aspect?
At page 100, my lord.
The particular aspect of what?
Aye. That page 106, my lord. Paragraph 7.
Paragraph
7, my lord. Of the rejoinder at page 106.
106.
Aye.
Pardon.
That the submission made in para 5 and 6 of the counter are not correct. The applicant was disallowed to inspect all the requested documents except the supply copy of past work verification report dated 28/3/2013. And the appellate authority also admits that I was not allowed. Appellate authority
ଏଇଟା ଗୋଟେ ଲେଖିଛନ୍ତି page number 105 ରେ the disciplinary authority did not permit the applicant inspection of the diaries at the time of record perusal before submission of his defense statement. As such, the applicant had not paid so on so forth. So that was, and what is the finding on that by the learned tribunal in the impugned order?
Learned tribunal only said that he limited judicial review. Para page 116, my lord.
116. Code report पढ़ो.
And last 8 line. The applicant in his appeal had taken non-supply of document as one of the ground and disciplinary authority in his order had specifically observed that the applicant perused all the available records related to charges.
But ultimately in para 9, if you come to 118.
Para 9 of the
read it, para 9.
Read it.
Para 9 read. Para 9, please read it.
Para 9 of the
188. 118. Sorry.
For the entire fact of the matter, it is revealed that the applicant seeks the tribunal to go to the merit of the decision taken by the disciplinary authority, which was upheld by the appellate authority by reappreciating and re-evaluating the evidence. It is settled law that the power of judicial review is an evaluation of the decision-making process and not the merits of the decision itself. It is to ensure fairness in treatment and not to ensure fairness of conclusion. The court or tribunal may interfere in the proceeding held against the delinquent if it is in any manner inconsistent with the rules of natural justice or in violation of the statutory rules prescribing the mode of the inquiry or where the conclusion or finding reached by the disciplinary authority is based on no evidence. If the conclusion or finding is such as no reasonable person would have ever reached or where the conclusion upon consideration of the evidence reached by the disciplinary authority is perverse or suffers from the patent error on the face of record or based on the no evidence at all. Judicial interference is warranted To sum up, the scope of judicial review cannot be extended to the examination of correctness or reasonableness of a decision of authority. As a matter of fact, further it is well settled that the court and tribunal in exercising its jurisdiction of judicial review would not interfere with the finding of fact arrived at the department of the inquiry proceeding except in case of mala fide or perversity, that is where there is no evidence to support a finding or where finding is such then that no man acting reasonably and with objectivity could have arrived at the findings, and so long there is some evidence to support the conclusion arrived at by the dependent authority, the same has to be sustained. Deputy General Manager versus Ajay Kumar Srivastava, no sir, this has been made out by the applicant.
No, it only non-suited you on the ground that there is limited judicial review. And the authority, they have taken a decision that should be final. In view of this finding, non-availing the remedy under the revision.
My reply would
detrimental to you. One remedy you have left.
Document was not supplied. Without supplying me document, only one document was supplied, but the authority in its order stated that I was allowed to peruse all the documents, but it is.
But you are disputing also to that.
Again, appellate authority ମଧ୍ୟ କହିଛନ୍ତି ଯେ appellate authority admitted the fact that no document was allowed to.
No document was?
And I was not allowed to peruse. I am taking your lordship kind attention.
What is that?
The appellate authority order.
Again, page number 74. Last but one paragraph. I have gone through the memo of charge, punishment awarded by the decisional authority, appeal of the appellant, and all other connected records of the case in detail and applied my mind. I find that the appellant perused all the available records related to charge, that is BO account number and report of 100% verification of balance of all type of accounts on 13/11/2018, being relieved on office arrangement. The applicant was also supplied with a Xerox copy of 100% verification report submitted him on 28/3/2013. The other requisition documents were found not relevant to the charges for which the same were not offered to him for perusal. I sought for certain document, only one document was supplied, and now the appellate authority says that those are not the relevant. But the dismissal authority says that all the documents I was allowed to peruse.
The petitioner, Vijay Kumar Sahoo, has approached this court challenging the order dated 11/8/2023 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 619 of 2019, missing the original application. Stop. It appears that so far the aforesaid OA was filed by the petitioner for quashing annexure A by 3 takmo.
Appellate authority order.
Dismissal order.
For quashing the dismissal order, so also the appellate.
The dismissal order of punishment order.
A by 3 was punishment order.
Yeah.
The punishment order and A by 8
appellate authority.
And the appellate
confirming order passed by the
confirming order passed by the appellate authority, and for a direction to the opposite parties to refund the money already recovered from the salary of the petitioner. Stop. The grounds have been taken inter alia in the original application that the petitioner has requested for supply of some documents, but unfortunately, those documents were not supplied to the petitioner, and the charge sheet didn't indicate the material particulars relating to the documents, and since the petitioner suffered serious prejudice for the non-supply of documents, the order passed by the authority in dismissing him from service, also the order passed by the
Yes.
appellate authority, are not sustainable in the eye of
Yeah, imposing the punishment of recovery.
punishment of recovery, not sustainable in the eye of law. Counter affidavit has been wherein stand has been taken by the opposite party that the petitioner was given reasonable opportunity to defend the charges, and he was allowed to peruse the documents related to the charges, and accordingly rule 16 was finalized. The petitioner filed the rejoinder affidavit to the said counter affidavit, wherein it is stated that the disciplinary authority did not permit the petitioner the inspection of the diaries at the time of record perusal before submission of defense statement, and the petitioner was disallowed to inspect all the requested document
Except one.
except supply of the passbook verification report dated 28/3/2013. The land council for the petitioner submits that even the appellate authority in the order, page
Again, page 74.
in its order has observed that
Last part to one paragraph.
that the petitioner perused all the relevant records related to the charges, that is PO account book, report of 100% verification of balance of all types of accounts on 13/11/2018 being relieved on office arrangement, and he was supplied with Xerox copy of 100% verification report submitted by him on 28/3/2013. However, the other requisition documents were found not relevant to the charges for which the same were not offered to him for his perusal. এটা ଅଛି page number 74 ଅଛି ହେଲା ରିଟ୍ ପିଟିସନ ତାର paragraph number 10 ର ମଝି paragraph ରେ. The land council for the petitioner argued that the London tribunal in the impugned order କୋଉଠି ଧରିଲେ
Page 116, madam.
has not given much importance to such non-supply of documents and came to hold that since the scope of judicial review cannot be extended to the examination of correctness and reasonableness of a decision of the authority, and the departmental proceeding finding, departmental inquiry proceeding finding cannot be interfered with except in a case of mala fide or perversity. Therefore, there is no scope for interference to the punishment orders, also to the order passed by the appellate authority. The Learned Council submits that the non-supply of outside documents has caused serious prejudice to the petitioner, for which an effective chokers could not be filed, and the Learned Appellate the Learned Tribunal should not have rejected the contention raised by the petitioner on this scope in a mechanical manner. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Mr. Padhi, along with Mr. Deepak Guchar, Central Government Council,
Extra copy may sir.
appears for all the opposite party. Extra copies of the writ petition we saw on the Land Council for the opposite parties. Matter will be listed after 4 weeks. Counter affidavit, if any, be filed in the meantime. Yes, next.
No,
You file your appearance memo. The Mr. Guchai shall file the appearance memo during course of the day. During course of the day.
notice is required on still after serving the.
They are appearing for all the opposite party. What is the question of?
No, they will appear all for all.
For all these, they are appearing that.
We are appearing for all. Don't take instruction.
Yes.
By Monday.
You give the copies by Monday and you will file the appearance memo during course of the day. Yes.
Item 4.
My lord, the annexure 5 and 8 is on the challenge, my lord. The annexure 5 is the order passed in OA number 200 of 2014 at page 34. So kindly see page 34, annexure 5. My lord, in this order, my lord, the WPC number 3605 of 2005 has been referred back. But that writ petition belongs to a different person and different cause of action. That does not no way related to the case of the petition.
No, what is this matter? This
Matter when the petitioner initially appointed to the post of
Your copy of OA is not there. You find the copy of OA.
My prayer is limited with regard to my review application has been dismissed, my lord, basing upon a palpably wrong order.
This is the order passed in the review petition.
Yes, ma'am.
So the number of
who is under annexure 8, my lord. Annexure 5 the order passed in OA and annexure 8 is the.
Acha, we read it that this is the order passed in OA.
Yes, ma'am.
OA number has been given as 260/200 of 2014. Your OA.
Yes, ma'am.
So what has been stated there? The Land Council for the applicant submitted that, as stated in paragraph 4, it is stated that applicant's claim for seniority was rejected in OA numbers also, and that applicant's seniority was fixed with effect after regularization of his service. The decision in OA number 17 of 1 so has been challenged in WPC number, which is Under consideration of so and so. So you, as it appears prior to this OA, you had already approached the Land Tribunal.
Yes, ma'am.
That is OA number 17 of 2003.
Yes, ma'am. That
And
yes.
that was dismissed, against which you have approached this court.
But I have not, my lord, also she kindly annexed 1 ma'am. That is the order.
ଏଇଟାକୁ ବୁଝାନ୍ତୁ ଆପଣ।
That does not belong to me, my lord.
No.
That is a different case, my lord.
ଏଇ ଯୋଉ OA number 260 ଏଇଟା ହଉଛି ବର୍ତ୍ତମାନ ଆପଣ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି। ୟା ପୂର୍ବରୁ ଆପଣ have you approached the tribunal earlier?
Yes, annexure 1.
So let us see that annexure 1.
That is in OA number 94 of 1994.
Himachal Pani Grant.
Yes, ma'am.
Achha, let us see. OA number 94 of 1994. So what happened? What is the result of this OA?
Yes. My lord, the operating portion of the order at
We allow this application and direct the respondent to regularize their service.
yes.
Okay, then what happened?
My lord, thereafter they have not regularized me.
Okay,
And still I am continuing the post of casual labor.
okay, then
Then thereafter, my lord, again I approached the tribunal in OA number 200 of
why? You should have filed the content petition.
My lord, they have appointed me in the post of forest worker, forest cum water carrier with effect from 1/3/1994, by the order dated 19/7/1999.
You see, when in the first original application, it was clearly stated in the operative part that your prayer is allowed, and the respondents, means the present opposite parties, were directed to regularize your service in the vacancies existing, and if there are no such vacancies, then they may keep in view the seniority in the waiting list. That was the
Till date I am in duty.
So if that order was, we are asking you that if that order was not complied with by the order within the prescribed time, you should have approached the same tribunal for filing the content petition. Why you filed a
Yes.
fresh OA?
In terms of the order passed in order annexure 1, my lord,
Yeah.
they did not act in terms of the order. That
Yeah.
is 5/12/1994, and the opposite party number 4 vied memo number 19/7/99 regularized the services of the petitioner in the part-time post of forest cum water carrier with effect from 1/3/1994. But the service conditions as mentioned in office order dated 9/2/1996 were made applicable to the petitioner. But there is scheme of regulation, and as per the scheme of regulation, they have not regularized me, and as the service benefit.
So just a minute. So this order which was passed earlier,
Yes.
in your case, 94 of 1994, that was never challenged in.
But they have complied.
ଏଇଟା
But in a
ଗୋଟେ
different.
ଗୋଟେ ଅଲଗା ଲେଖିଛନ୍ତି।
Yes.
ଏ ଯୋଉ way number ଟା ବି ଅଲଗା। 17 of 2023 is not your.
Yes. No.
And a WPC ବି ତ ଆପଣଙ୍କର ନୁହେଁ। No way related.
WPC no, annexure ବି ଦେଇଛି next annexure 6 and 7.
So way dismiss କଲା ପରେ ତାପରେ କଣ କଲେ ଆପଣ?
I filed a review application.
କାଇଁ?
That is annexure 8, and annexure 8 the order part is the review petition.
Review petition ରେ କଣ ଲେଖିଲେ?
Naturally, at this stage we cannot review the order in its entirety.
Yes, Mr. Padhi.
Yes, man. But they in para 3 of this application, page 39, it was discussed, my lord, by the learned tribunal.
39.
Page 39, para 3 of the RA, number 260 of 2008. The applicant filed a review application seeking review solely on the ground that the reference of OA number such and such, W such as met in the order dated 9/9/2019, OA number 2000 is wrong because the applicant the OA number such and the
wrong.
Connection with the present
OA
case.
number 17 of 2003. And this WPC is no way connected to the petitioner. He has filed a OA which has been allowed. that you come to the annexure 1.
Yes,
Annexure 1
I,
is
I've
actually
seen that. Yes,
previous
I've
way.
seen that.
So OA was allowed and the direction was given to regularize his service. And if no vacancy is available, then waiting listed, his name is to be.
May I pray, your lordship, may keep it to some other day. I'll ask the department to give you the OA copy. If the OA copy is not there, then will you come to a conclusion, my lord?
OA number 94 of 1994. Acha, you do one thing. You also file this original application. Have you not? Why have you not filed? In this case, counter affidavit filed. You second challenge করবে order.
Applied the certificate.
So the documents are not there in record. So we'll accumulate the documents
OA
first.
number 260 ଆପଣ ଏଇ original application ଟା file କର ଲେଖନ୍ତୁ the writ petition has been filed by petitioner Simanchal Panigrahi for setting aside the order dated 9/9/2019 passed by the London Central Administrative Tribunal in way number 200 of 2014. So also the order dated 6/5/2025 passed in RA number 260/0008 of 2021. The contention of the London Council for the petitioner is that when the petitioner earlier approached the London Central Administrative Tribunal in way number 94 of 1994, seeking regularization of his service, the prayer was allowed by the London Tribunal and by order dated 5th December 1994, opposite parties were directed to regularize the services of the petitioner in the vacancies existing. And if there are no such vacancies, then it may be kept in view that the seniority of the petitioner is maintained in the waiting list. The Land Council submits that the order of the London Tribunal was not complied with, and the petitioner was posted as a
Casual labor. He is now posted part-time forest cum water carrier as casual. Paragraph 6
in the writ petition.
Yes.
And the petitioner was posted regularized in the services in the as a part-time post of forest cum water carrier with effect from 1/3/1994. But the service condition as mentioned in the office order dated 9/2/1996 were made applicable to the petitioner. The Land Council further submits that the petitioner filed the second way before the London Tribunal, which was registered as way number 260/200 of 2014. And the London Tribunal in a cryptic order dismissed the original application, holding erroneously that the petitioner's claim for seniority with effect from 10/2/1991 was rejected in OA number 17 of 2003, and that the petitioner's seniority was fixed with effect from 1/3/1994 after regularization of his service, and that the decision passed in OA number 17 of 2003 has been challenged in WPC number 3605 of 2005, which is under consideration before this court. The Land Council submits that neither that OA number 17 of 2003 belong to the petitioner, nor any such writ petition as has been mentioned in the said impugned order relates to the petitioner. Therefore, the petitioner filed a review application before the London Tribunal, pointing out the illegalities committed by passing the order dated, what is that order? It was dated 9/9/2019 in the original application. However, the London Tribunal has been pleased to dismiss the review application, holding that in view of the limited scope of power of review, the order cannot be reviewed, and dismiss the hearing. Stop. Since Mr. Padhi has already entered appearance for all the opposite parties.
Yes, all the opposite parties. All the opposite parties.
All the opposite parties. Extra copies of the writ petition be sought on the Land Council's sponsor. The Land Council for the petitioner shall file the copy of the OA number 260/200 of 2014. Matter be placed on such and such date. Counter, if any, be filed in the meantime. Issue notice service. Yes.
Mr. Samantara is appearing with me. Is in court. Lakshmi referring that.
Give
Yes,
your
Samantara.
name and the designation. Yes.
Item 5.
May I please, my lord? My lord, Annexure 3, that is order dated 26/9/2025, passed by the London Tribunal in OA number 715 of 2024, which order impugned in this case, my lord. The case of petitioner before my lord is that her husband and 8 others, they were before London Tribunal in a 9 original applications regarding grant of SCP on the financial operation under SCP scheme, my lord. In lieu of difference opinion between member J and member A, the matter was referred to third member, my lord. Third member passed the order under annexure, that is annexure A by 2, starts from page 29 of that OA. That order came in negative way, saying that grant of financial operation is not a recurring cause of action. Accordingly, all the original application dismissed only on the ground of limitation, in spite of settled principle of law confirmed by this court as well as upheld by the honorable apex court. So again, they approached this court by filing 8 writ petitions, my lord. 9 writ petitions. Out of 9 writ petitions, my lord, the order passed in the original case that was quashed. Accordingly, 8 original writ petitions order passed in the same line. But in case of this petition, order passed, that I want my lord place, while dismissing a similar matter filed by the present opposite parties, where the London Tribunal was pleased to allow the original application, this court disposed of my writ petition, saying that in view of dismissal
of that writ petition, this writ petition disposed of without expressing any merit or opinion in this case. So I file an IA for modification. That was rejected. After implementation of my last order in favor of middle class persons, the petition made a difference with a plea as the original order passed the law by law tribunal, quashed by the Honorable High Court, deems to have been the order passed in case of my husband, deems to have been quashed. So I made a representation. They have not acted upon a reminder. Then I approached the law tribunal saying that you extend the benefit as granted to similar 8 persons, my lord. So, my lord, may I pray, my lord, the law tribunal has given a finding that page 96, my lord, that is the impugned para 6, last page, my lord, last 3 lines, man, did not yield any result. I'm reading. MA number so and so, consequently when so filed by the husband applicant seeking the similar relief had already been adjudicated, dismissed, challenge of which in WPC number so and so and subsequently IR number so and so before the High Court did not yield any result. This part is not correct. May I pray, my lord? Your lordship kindly give answer to para 6 of the counter. What is the case of present opposite parties before the law tribunal? Page 87, man.
No. Have you in your requisition,
Again.
the original application,
Again.
have you highlighted about these?
Again. Para 4.8, 4.9.
Just a minute.
My lord.
4.8 and 4.9.
9, 10, then 12 is very important.
Yes.
My lord. Page 21. Starts from page 20, my lord, 4.8 of that one.
You want to place 5.8?
My lord.
Also.
The order of rejection dated 18/6/18 was subject matter before this on tribunal in one or so and so along with MN number so and so. The original application number 407 of 2018 and others were heard by a division bench and reserved for orders on 22nd October 2020. Because of difference of opinion on the question of limitation, the matter was referred to Honorable Third Member. The Honorable Third Member by order dated 17 March 2021 was pleased to dismiss the MA according all the batch original applications dismissed by order dated 17/3/2021. 4.9 man. The order dated 17/2021 was under challenge before the Honorable High Court of Orissa in a series of writ petitions, including WPC number 35841 of 2021, 13596 2021, and others. The Honorable High Court, by order dated 1st December 2022, was pleased to allow the prayer made in WPC number 13596 of 2021 and other writ petitions subsequently. The order by the Honorable High Court in different writ petitions implemented by the order dated 9th 2023 and granted first finance operation under SCB scheme with different dates. Then 4.10. The WPC number 35841 2021 filed by the present applicant was listed before the Honorable Court on 14/7/2022 along with WPC number 8083/2018 filed by the present respondents. The Honorable High Court was pleased to dismiss WPC number 8083 of 2018 and confirm the order of this Honorable Tribunal passed in favor of Keshav Chandra Mahapatra. In view of dismissal of WPC number 8083/2018, the Honorable High Court was pleased to dispose of WPC number. Then, my lord.
How you say that your case has been allowed or disposed of in the light of the observation? Where is that order?
That order I have enclosed as annexes.
Where is the order of this court? 17/3/2021, against which you filed an IA, which was dismissed. So therefore, the tribunal says that the principle of estoppel and res judicata operates. Same issue you can't reinstate.
Your lordship, kindly give a glance page 65. Order passed in WPC number 8083 of 2018. 85. That writ petition was filed by the present opposite parties.
Which number page?
65, my lord.
It's a non-appeals regard.
So now, my lord, the order passed in my case, page 68.
In view of the order passed today, we connected the proceeding.
On a physical line basis.
Nah. So I file an IA.
That IA is dismissed.
If the order would have been that in view of the order passed in that.
That WPS number,
Where is the order in 8083 18? So as
page 65, ma'am.
therefore, should dismiss it.
That writ petition was filed by the present opposite parties challenging an order passed in favor of employee by the law tribunal. Ma'am.
No, this particular order 14/7/2022, it does not have gone in your favor.
No, ma'am.
So
Not decided it.
Not decided.
So
Not decided.
you filed an interim application
I guess
to recall that order.
for modification.
You decide to modification.
Modification.
कौन है से तो?
That was
That is also dismissed. So therefore, now the tribunal says that it's now res judicata, estoppel.
Where is that IA order?
Justice Harry just Justice Harry justice କରି
ଆପଣ ତ କହିଥାନ୍ତେ ସେ order ଟାକୁ ଆଣିକି
My lord,
ଏଇଟାକୁ ଏଇଟା ହେଲା
I am appealing before my lord and in various cases, my lord. To that, my lord, I don't want to say anything because rightly or wrongly an order passed by my lord. So I am here before my lord. I am appealing in series of cases before my lord. Whatever that may, when that order is passed, I don't want to say anything on this
Okay,
order.
all right. We understand, but
It
what
was-
is the order passed in that IA?
IA order this.
Sir, boss.
Have you filed the IA copy? Can we get that IA copy? What ground you have taken in the modification? Have you showed all this thing to the court?
I can file. I am with that.
Where is that application? What have you written that in that
I
application?
can file the next.
ସେ application ଟା ଆଣିଲେ ଜଣା ପଡିବ ନା ଆପଣ ସେ ଗ୍ରାଉଣ୍ଡ ଗୁଡା ନେଇଛନ୍ତି ନା
ଆଜ୍ଞା।
କଣ କହୁଛନ୍ତି?
अच्छा लिखो
Moreover, my only prayer, your lordship only see kindly give a glance page 87. That is para 6 of the counter filed by the present opposite party before on the counter.
87
Mile
वो paragraph
6. It is humbly submitted that Honorable Cat, where is order dated 17 March 2021, has dismissed the MA number so and so and 8 batch on similar issue. The order dated 17th 2021 was challenged before the Honorable High Court in series of writ petition, but the Honorable High Court, by the order dated 1st December 2022, was pleased to allow the prayer made in double petition number so and so and other writ petitions, but excluding the double petition number so and so filed by the present applicant. The Honorable High Court was disposed of writ petition number so and so on 14/7/2022 in view of order passed in writ petition number 8083 of 2018. But it is very peculiar that no particular order has been passed by the Honorable Court in double petition of so and so, which is disposed of due to non-appearance, non-prosecution of the petition at the time of. So there is no clear-cut order passed in double petition of so and so.
एटा दियो भी आई एटा
Where is the order dated passed in 13596/21?
Mile.
ये order ता दिखाऊं
That must be the detailed order.
Again, page 60 mile.
Page 60.
Again,
13596.
96 of 2021.
Page 60, huh?
60.
This is the detailed order.
Mile.
In fact,
This is the order passed in the
that is the
original order mile.
the order पड़े जो अन्य order को
Again.
गलत लिखले এই নম্বর লিখিয়া
हाँ
এই নম্বর লিখিয়া था সেই নম্বর
So the original order passed before law tribunal was by this order mile. The main order passed by tribunal was by this order.
So you have benefited by this order.
Mile.
So then the number of writ petition number was wrongly written in your case. In fact, this number should have been written We have passed this order in a detailed order in this writ petition instead of that other.
We also just want to see that in your writ petition, what was the prayer made? Yes, writ petition. Have you got the copy of the writ petition? Whether the same prayer which has been made in this writ petition has been made or not?
Challenging the order dated 73/2021
My lord.
of the
Let us see.
tribunal in series of matters.
Right.
Why don't you file all these things? See, some wrong has taken place, and if you don't file, another wrong will occur. So why don't you file all these things? Don't give these papers. Let him file it. You file everything.
The
See,
Land Council,
there is a-
we are just adjourning, you file the entire documents.
so that the mistake can be corrected.
My lord.
The Land Council for the petitioner takes some time to file relevant documents for adjudication of the writ petition. This matter favor of your Fred detailed you.
Aye.
Please.
ସେ ତାଙ୍କର ପିଟିସନ କପି ଯୋଉ WPC ଯୋଉଟା ଆଲାଉ ହେଇଛି ଯୋଉଟାରେ ପାସ୍ ହେଇଛି
ଆଜ୍ଞା
ଏଇ ଯୋଉଟା
13596
ଆପଣ ଖାଲି ତା ଅର୍ଡରଟା ଦେଇଛନ୍ତି ନା
ସାର୍
ତାର ରିପିଟିସନ ଟା ଦିଅ ତା ପାଖରେ ଆପଣଙ୍କ ରିପିଟିସନ ଟା ଦିଅ ଯୋଉଥିରେ ଜଣା ପଡୁଛି ଯେ ପ୍ରେୟାର ସେମ ଥିଲା
ଆଜ୍ଞା
ହେଲା
ଆପଣଙ୍କର ଆଇ
ଆପଣଙ୍କର ଆଇ ଏଟା
I have read copy of mine and I have copy of mine at
I
present.
is more.
and we just want to know that whether in your repetition the prayer is same or not.
ଆଜ୍ଞା
According to the କେବେ ରଖିବା କୁହନ୍ତୁ ଆପଣ
1st of December, my lord. I can file by tomorrow or day after tomorrow.
this matter on 3rd December 2020. Yes.
Item 6.
Please, your party. All the petitioner are villager, your lordship. They're opposed. All the petitioner villagers, they, the fact they are objecting a route of.
What is your prayer? What is your prayer in this petition?
Yeah, lordship, challenging the OESC order as well as the collector order, your lordship. That is, there is page number 22, your lordship.
This order is dated 8/10/22.
So the first is 4th October 2025, Annexure 5.
Annexure 5.
Your lordship.
4th, yes. This is 4th or 8th?
This is 4th is the order passed by the OESC, and the collector is the order is the 8th May 2025. The two orders I am challenging.
Against the order of the collector, there is no other forum.
I file a revision. The revision is order rejected, Annexure 5, page 50, your lordships.
What do you want to say that have you availed all the remedies available?
Yes, yes.
So the revision order may
Annexure 5, page 51 starts. Your lordship.
Annexure 5.
Your lordship. Start from page 51, your lordships, the order part.
So as it appears, the collector's order is dated 8/5/25. You would have dismissed in the last paragraph.
You are the villagers.
Yeah, I am the villagers.
You are objecting to the 11 kV overhead supply line.
Yes, our villager. I am saying the alternative available, but they have not considered.
What is their stand?
They say, the revisional court say that this is cost effective. My humble submission, that is your lordship's paragraph 57, your lordship page 57. Because of your lordship, they have page 57, paragraph 15, your lordship. Paragraph 15, your lordship. 1-5, your lordship. Revisional court order. The petitioner have also vehemently urged, when there is a availability of alternative route for drawal of lines, the proposed route should have been avoided. This, according to them, was not considered by the learned collector. There are no express provision that the prescribed for drawal of electric line alternative route shall be preferred to the village road. The regulation formulated by the commission make that the object clear to the extent that the consumer of electricity shall get power at the reasonable cost. If we put it differently, both safety aspect, life or property, and the cost factor need to be considered during the selection of the route of drawal electric line. As is evident from the submission of the parties and the material on record, an alternative route for the electric is available. Is available in the area through which power can be supplied to the proposed rice mill of the opposite party number 2. But fact of the matter is that opposite party number 2 in the process of incurring additional expenses which should go against the policy that supply out shall be cost effective.
We know this Patak District Court complex, which is to come in front of that Australian hospital.
Yes.
Over that, an 11 kV line has gone. And the proposal has been given to change the route.
Yes.
And do you know what is the cost of that changing of route? It amounts some crores. 11 kV line ta upare jaichi, se plot upare, taku change kariwe, it would cost some crores. So that is because of that is a court thing. So but say rice mill pay out a route and
it is already not installed, my lord. My humble submission, if your lordships. Here is a case not installed. They are only drawal is able to install in.
The collector has dealt with para 50 Jesse reasoning.
Collector?
Yes, 57 division of para 50.
Yes,
But we need para 50.
So collector order, your lordship.
Annexure 5.
Yes,
para 57. Page 57, para 5. 50. Para 50. Page 57.
Yes, paragraph 15, your lordship. This is the revisional order.
There he has dealt with all.
No, my humble. It was not dealt by the collector, my lord. What I am submitting.
Where is the collector's order?
Yes, your lordship. This is annexure 3, your lordship. This has not been discussed, my lord. The collector, my lord, on the basis of assurance of a rice mill, he passed an oral assent, your lords, in absence of any order. Page 32, your lords. Page 32, annexure 3, your lords. Start.
And this matter has also come earlier to the High Court.
Yes, directed to consider by the collector rule. The procedure to follow, then I appraised before the collector. And before the collector, principal ground before the revision, I have not given full. Villager were present, but it was not hearing, effective hearing was granted, your lordship. Your lordship, page 33, your lordships. But the High Court order was quoted, your lordships. And the 35 is the available submission, your lordships, the parties, my lord. Third paragraph, your lordship. Now, Srimati Sahoo, present and hearing, assured that wires so extended from the village are sufficiently prescribed height with high safety, which cause zero danger to any life and property, my lords. And this is the submission by the rice miller, my lord, overall submission. There is no document recorded by the. Thereafter, your lordship, kindly see the TPC Dell submission, my lord. No, where is the considering the submission by the petitioner opposite party number 5 TPC Dell in compliance with the direction issued by this honorable court that in the light of honorable directive and the submission presently, it is hereby ordered, Miller, 11 kV line including GI pole shall be installed and the statutory prescribed height with appropriate safety insulation, thereby ensuring danger of life property, Miller. The placement of electric poles shall be executed such manner that they don't obstruct any interval with the pedestrian or vehicular traffic movement of livestock, any other activity essential to the daily life of the village inhabitant. the installation of the electric infrastructure of the commercial purpose is deemed to be compliant with the safety standards and the procedural requirement, and the executant is therefore permitted to proceed with the boundaries of the respective guideline and laws. They allowed the same route village, which is revision preferred. Since the executor ensured adequate safety, since the executed ensured, this is only oral submission, my lord, I say, the submission I said, your lordship, his submission. Since the executed ensured adequate sufficient safety in installation of electric wires and poles, following the pecuniary measures, there will be no issue on the safety of the
That is
villagers.
his observation, because he has, the order is 1, 2, 3 are his order.
Again,
Apart from that, he has stated that adequate safety is to be thing, and there will be no issue on the safety of the village.
Lord, the collector has not discussed, your lordship, the safety page 33 hour submissions, my lord. Page 33, your lordship. Same order, page 33, my lord. Third paragraph. Where the petitioner state that the Sahoo intends to establish a mill under Mukhyamantri Krishi Udyog Yojana. She approached the seeking permission and electric connection. Paragraph 3, your lordship. Last.
So when the magistrate has considered all these aspects, and what is the flaw in it?
Yes,
What is
Miller,
the
flaw is number of legal Miller. The first of all, the court not considered the rules Miller 3, which is applicable to the two.
No,
and
how is this writ code will
no, your lordship kindly see the impung order, your lordship. Miller, the learned court, the regulator.
What is the danger you are apprehending?
Yes, Miller, there
Where
is
is the
school.
material that affects?
Yes, Miller, they have not denied, Miller. There is no denial of that village road.
That
Miller.
is the reason the collector says that take all the
No,
measures.
Miller, my humble submission. Miller. I guess school, see, guys, Miller, my humble submission, with your lordship, that there is a provision for Miller site visit inquiry in the guidelines. Miller. Collector also not
That is
visited.
how the collector has taken that all the safety measures are to be taken, and thereafter all these things. So that is the order is very clear.
Miller, there is no certificate on safety certificate in oral submission. They assured, Miller. By your lordship, kindly have the impung order annex of Miller page 55 again. Your lordship, I requesting.
The 11 kV swan show shall be installed at the statutorily prescribed height, number 1, with appropriate safety insulation, number 2, and there should not be any kind of danger to the life property. Then the placement would be such. All these things have been stated.
Yes, they have only oral. There is no license. There is no record. Your lordship, kindly see the regulation. Your lordship, page 55. Your lordship, kindly have the impung order. They have quoted.
They have not yet commenced the work. They are supposed to commence. Once they started it, then these things are to be all these.
They have not started, Miller, because we are Miller. Your lordship, kindly page 55.
In case any later after the commencement of work,
available thore once cost of villages alternative gotte taro jiwa khali rice mill pe alga available achi. They admit there is available, lordship. Page 55, lordship. Lord, our they say that we are Lord, is legally
whatever the collector has said, and now the revisional authority has added something more to that.
Exactly.
Kindly see para 15. Therefore, I am saying
yes,
it says that all safety measures have to be taken.
No.
Very clearly, it says.
Your lordship, kindly
see page 15.
Page 57, lordship.
57 page, para 15.
Yes, lordship. The topils, the opposite party to examine the technical phases shall not ignore the safety measures, which are also paramount of consideration. As observed, the made no compromise of the, as observed above, the opposite party number 1 has made no compromise of the safety measure during the field visit. Your lordship, that your lordship, I humble submitting, your lordship. There is no field inquiry submission in the collector order, your lordships. Your lordship has perused the collector order. There is no collector order. The statute provides, they have to collect an alternative site. What is the cost effective?
That may not be there, but there is a inquiry. There was a site visit.
But it has
not been. That's what the revisional authority takes note of.
It has not been appeared in the collector order with the humble submission, your lordship. No, Miller, why I am error, Miller? Then we submit, 2-3 legal submissions, Miller. I may be, 1-2 minutes, your lordship, kindly, Miller, kindly. Your lordship, can you see the order, page 55, lordship? Your lordship, they revision, Miller, they relied the CPC provision 119, page 56, your lordship.
in the case number so and so. Will confirm me the order passed by the collector and district magistrate Tenkana dated so and so under Annexure 3. On perusal of the order passed by the collector, it appears that the petitioners approached earlier this court in WPC number 8535 of 2025. And the prayer for not allowing the installation of 11 kV electricity line and electricity pole through the village road in Taladanga village of Dhenkanal district. This court by order dated 25/3/2025 disposed of the writ petition and directed the collector to consider the representation of the petitioner expeditiously and to communicate the decision to the petitioners. It appears that the collector, after hearing the petitioners as well as the authorities of the PPCODL, PET Chang Park, so also Srimati Soirawala Sahu, the opposite party number 5, has been pleased to hold as follows. Quote paragraph that is page number 35 and 36. Judiciary now therefore in the light of honorable সেইটি এখন এই দিকে শেষ পর্যন্ত dispose of authority শেষ পর্যন্ত challenging the order of the collector and district magistrate Dhenkanal, the petitioners approached the OERC Salesur Bihar by filing the revision petition number 45 of 2025. The Land Revisional Authority, after hearing the parties, came to hold as follows. Quote paragraph number 15, 16 and 17 minutes entirely. The Land Council for the petitioner submitted that when there is an alternative route for taking the electricity line is available for supplying the power to the proposed rice mill of the opposite party number 5, the collector as well as the revisional authority would have considered the same and directed the TPCODL authorities to take the electricity line in that route, which would have no way uh, um, become dangerous to the petitioners. However, we find that in addition to what has been observed by the collector in the impugned order dated 8/5/2025 for taking safety measures, the revisional authority has passed some further orders relating to the safety aspects and very specifically observed that in the process of giving cost-effective power supply, the executing authority, that is the executive engineer TPCODL, shall examine the technical feasibility and shall not ignore the safety aspects which are of paramount consideration. And there should not be any kind of compromise on the safety aspects during the field inquiry, public site visits. In view of such order passed, we don't find any illegalities in the orders of either the collector or the divisional authority necessitating for an interference when all the safeguards have been stated to have been followed, directed to be followed by the authorities concerned for taking such 11 kV line. Accordingly, the writ petition being devoid of merit. Next.
Oblige.
Item 7.
Yeah, please, ma'am. Petitioner is an associate professor, Manoj. Yeah. He challenged the issuance of the charge sheet on the ground that the charge sheet was issued without jurisdiction before the learned Central Administrative Tribunal. Now, the tribunal, at first blush, even though admitted the application and granted interim orders, but subsequently at the time of hearing, the tribunal held otherwise, that no, it's not without jurisdiction. And
Mr. Palit, the order which you are challenging before us,
that is
annexure.
Annexure, my lords, 18.
18.
At page 173. Starts at 172.
Where is your original application?
Original application file.
And whether any counter was filed?
Yes, counter was filed in CAT.
No. We are insisting in all these type of matters where the order of the learned tribunal has been challenged to file the entire pleadings before us, so that
I'll do that.
Better for us to.
I'll do that.
So we can take up any day as you suggest.
My lords, I'll do that.
Counter, if any, and if we can.
Counter and the
if any.
Pleadings,
Entire pleading.
Can I file it by way of a separate memo so that?
No, you have to. That is to be filed so that it could be stand and come to us. So
in
advance.
Would your lordship require it as a formal amendment or?
No. That order has been passed and it has been that wherever the order of the learned tribunal has been challenged, the entire pleading should be before us.
We have requested the registry to have a standing order to that effect. And wherever there is a challenge to the tribunal's order, then the entire pleading has to be filed.
Man, I'll comply, man. Your lordship may kindly grant me please 26.
That December month calendar.
Your lordship may give me a date in December.
Third.
Or can you?
Third. I'll.
Since
on the list, I'll find
the order under challenge before in this writ petition is dated 13/10/2025, passed by the Land Central Administrative Tribunal, Cuttack Bench Cutting in OA number 260/00711 of 2020. Mr. Suvit Palit, Land Senior Advocate, appears for the petitioner and seeks for an adjournment when bring entire pleadings before the Land Tribunal on record. List this matter on 3rd of December 20. Yeah.
And we received the petition or whatever additional document they filed, they may serve the copy to us. Petition copy they serve.
Copies to
I'll
be
comply.
yes. Tahana lekha.
My lord, the SS question. I'll pass on his statement.
Please pass the file that appearance memo.
That's
Yeah.
Item 8.
May I submit the system?
Yeah.
My lord, I'm challenging the order of learned CAT dated 9/10/2025, page number 132 to 136. The background of the case is that a charge sheet was issued for recovery for an amount of 58,190. But before issuance of charge sheet, under assurance and duress, I have deposited an amount of 1,53,000. Charge sheet was only 58,000. So accordingly, I have submitted a representation dated 7/12/2019 to get it recovered the excess amount of the charge. Annexer A/3, page 70. As there is no action from the respondent, then I filed an OA. OA, my lord, 127 of 2000. And they have given in the counter, they have only baldly mentioned that amount is around 2,53,000 without any documentary evidence. On that basis of counter submitted by the respondent, learned tribunal has given the order that since I have not denied anything to the counter, so it is not justified to give any order for refund of excess amount of 94,800. But my lord, in my rejoinder, at page
They
1,
had not asked you to deposit this amount. This
because
58,000, you on your own. Apart from 58,000, you deposited 1,53,000.
my lord,
Perhaps you were anticipating that the misappropriation amount may be to that extent. That is how you deposited. Now they have come up that the misappropriation amount is rupees so and so. So there is no question of refunding them. So ultimately it is to be adjudicated what is the and you will get that why the amount will be refunded.
but my lord, in the charge sheet, it is only 58,000. And no other document they ever submitted or justified that it is 2,53,000.
Where is that charge sheet? Let us see. Have they asked you to deposit this amount ever?
No, my lord, before issuance of charge sheet, when they kept me on foot of duty, on mutual assurance basis that nothing will be done, it was only returning the excess cash, my lord.
Let us see that amount which you say that it is only 58,000 or all.
Oh, my lord.
Where is that?
Page number 18, my lord.
Where is that amount?
Page number 18 to
Amount of the
amount, my lord, in article of charges, 5 article of charges.
amount देखा कोड लिखा है जी अपन डिपॉजिट करबो
ମୁଁ जो डिपॉजिट करछि माइला
अपन डिपॉजिट करन तांकर जो कहउछन 58,000 बिली कोड सेटा लिखा है जी देखांतु
माइला जे पांचटा आर्टिकल ने टोटल मिसेले फीस 58. माइला charge 1, page 10, 65,000, 53,000, 4,000.
charge 1 ने कितना है ना article 1 ने
6500.
If lordship come to page 97, it is clarified. Page 97 order That will cover particle charges 1, 2, how much amount is this. It was consecutively given. Page 97, 98, 99.
ठीक 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 तो तीनटा अच्छी
Char 103 page article 4 touch. 6 touch.
No, he says, Mr. Pari, what he says that if the entire amount is added, that means under different articles, if it is added, it comes to 58,000 odd, which he thought that I should deposit more. So he deposited 1 lakh some odd. So how, where from the, you found that this is 2 lakh and odd? এটা কোড পাইছে মানে এই যে total amount of permanent loss.
My lord, they are given in the counter, my lord, before the learned.
Where is that counter affidavit?
6 page 83, my lord.
মানে সেই যে 2 lakh oddটা কোড লিখছেন খুব পারবে পৌঁছলো আচ্ছা পারা পেজ নম্বর 87
87, my last part.
87 on conclusion of the verification work, it was found that Manas Ranjan Das has committed permanent misappropriation of rupees so and so and temporary misappropriation of rupees so and so in 34 numbers of saving accounts so and so. So that is the reason they said that after election, the last 4 lines, they said Das has voluntarily credited part of the amount 1,53,000 but has failed to credit the rest of the amount. As a result of which the rest of the amount has been recovered from Swan. So very
My lord, there are only 5 accounts. They have mentioned 36 accounts. In my rejoinder, as page 53, my lord, 93.
এই কাউন্টার উপরে আপনার রিজাইন্ডার কোন ছিল?
My lord, I have denied all this.
All these ওরা কোন বর্তমান jurisdiction how it can
calculate all this thing.
But
in this jurisdiction, how we will calculate all this thing? What is the loss? What is not the loss?
they are stating it is 2 lakh or
my lord,
Can we say that it's less than that?
my
Can
lord,
we say? Are you
charge sheet was
conducting a
only
crime here?
58,000. They have not given
so
any
they have
document.
stated that what is given the details.
Documents. They never submitted anything nor given any chance to prove that whether it is 1,53,000 or 94,000.
In counter page 87, we have described 2,11,690.50
Departmental property.
Then this total is coming 2,56,641 of 37 paisa. It was clarified in the counter itself.
Page
Page 87.
Yeah? What is the stage of the proceeding?
He is not being removed. Only a proposal was sent. Punishment order, my lord. 31 to 40.
We are not entering this disputed thing.
My lord, page 40. Last para I am reading. In view of aforesaid discussions, it is hereby ordered that Sri Manas Ranjan Das, GDS BPM Baisinga BO in account with Bodoswal SO under Dhankanal HO, now under put up duty, be removed.
You are not challenging anything.
No, that is in another date I am not doing that. But my submission is that, my lord, only charge sheet was 58,000. I have deposited.
No, we will not.
The writ petition has been filed by the petitioner Manas Ranjan Das challenging the order dated 9/10/2025 of the Land and Central Administrative Tribunal, Cuttack Bench Cuttack, in file number
केस कौन की केस
260/00127 of
फेउटा सरजाने को पाठ को केस नांदी पति से केस रो खोजुचंदी एका उकिल ना नन एप्रिल चलन करछ
factual scenario
ए जो आइदर फार्मेसी काउंसिल
the
थियो नि
petitioner by the original application
सीधर सब पई कोई एप्रिल कर
direction
रजनी
to the opposite
तो
parties
समस्त
to
पई कोई
refund
रजनी एप्रिल करियो
the excess amount of rupees 94,810 with penal interest and compensation towards the legal expenses. It is his case that while he was working as Gramin Dak Sevak in branch, post master Voishanga branch officer, in the account of Bodoswar of his soul under Dhenkanal Postal Division, he accepted an amount of rupees 58,190, but did not credit the same in the concerned saving bank and recording deposit passbook of the passbook holders, for which a disciplinary proceeding was initiated against him. It is a further case that the petitioner deposited a sum of rupees 1,53,000 at Kamachanagar SO under the head of classified receipt. And since it was the case that the misappropriation amount of was rupees 58,190, therefore he prayed for refund of the excess amount deposited by him, which is 94,810, which the opposite parties did not refund despite repeated requests. After issuance of notice, the opposite parties entered appearance and they filed the counter affidavit, wherein a specific stand was taken that during the incumbency period of the petitioner, on verification, it was found out that he has committed permanent misappropriation of rupees 2,11,690.50 paisa and temporary misappropriation of rupees 96,736 in 34 number of saving account oblique recurring deposit accounts oblique Sukanya Samriddhi accounts standing at his branch office, and the normal interest and postal interest on the defrauded amount has been calculated and arrived at rupees 31,279.51 paisa and rupees 13,671.36 paisa respectively, and thus the total amount of permanent loss sustained by the department due to fraud committed by the petitioner is rupees 2,56,641 and 37 paisa. However, since the petitioner voluntarily credited a part of the amount, that is 1,53,000, but failed to credit the rest of the loss amount. Therefore, the question of refunding the amount, excess amount as paid for by the petitioner doesn't arise. The petitioner filed the rejoinder affidavit to the counter filed by the opposite parties, The learned tribunal in the impugned order has been pleased to hold as follows. Quote paragraph number 4. After going through the pleadings of the parties,
My lord, also observe the para 5
para 5, the para
of the page 90. Page 90, above read by the para 4.1, where the applicant committed misappropriation 34 number of accounts under different schemes standing. Yes, it is more clarified.
Counter paragraph number 5. The learned tribunal, we find that the question of disputed question of fact, and it cannot be adjudicated within the in this writ proceeding, and moreover, we don't find any illegality in the impugned order passed by the learned tribunal according to the jurisprudence the word of which stands dismissed. Yes, ma'am.
Item 9.
Yes.
I may please your lordship. The petitioners a challenge without affording opportunity by opposite party number 13-4 notice has been no notice was served upon me, my lord.
No, 13-4 notice has been issued. So
Yes,
you have got the alternative remedy, not
Yes.
here.
Yes,
have
my
to
lord.
go to
Yes,
the
yes, my lord. I am pressing the things.
No, you are the borrower.
No, my lord.
No, who are
They in a clandestine manner by playing fraud.
we are asking you, who are you?
Myself stood as a guarantor as proposed by that.
So, approach the 13.
My lord, I am submitting. They have committed fraud. The opposite party number 1 committed fraud.
Highlight all these aspects who has committed fraud. It is not in the writ court all these things.
That apart, I humbly submit before your lordship the fraud committed the recent decision of Honorable Supreme Court in the Central Bank of India versus Saini Prabha Jain. This is the fraud committed that is
Fraud, how will in the writ jurisdiction, how we will ascertain fraud?
My lord,
You
that
have to
will
go
be
on
not
the
by
right
the
forum.
crime. Not by the
What is that?
my lord.
It's alternative remedy and it requires evidence to be adduced. And how this writ court will entertain all these things?
My lord, objection that is amenable to the
All the
civil court jurisdiction set aside.
For setting aside the auction sale notice. It is not auction sale notice, it is a 13-4 notice issued by this.
My lord, there auction sale notice is also there.
The auction sale notice.
Yes, my lord, I am pleased. There is no issue, my lord.
In view of this one, so decision, since alternative remedy is available without expressing any opinion, also the petition is at liberty to seek such remedy. Only the petition is disposed of. Yes, next. Right.
Item 10.
That the petitioner is agreed by the rejection of. I have been instructed to appeal on behalf of the opposition bench. Maybe promoted to so that I may. No, I don't have. I will solve copies, but your lordship may kindly, because there is urgency. Your lordship may kindly straightway come to page 23, annex or 4, where my lord's OTS was accepted and they directed me to pay sum of 2 crore 1 lakh within 3 months, and it was by the order dated 29/9/25. And the 3 months means it will end in 28/12/2025. So first installment they said back in 3 equal installments. In the first installment, I could not pay, so I made an application before the authorities. Grant me some time. First installment of 67 lakhs I will deposit immediately. But that application was made on 10th. On 10th itself they rejected.
11th of them also published a notice in the newspaper for sale of that property, fixing fee.
Go and approach the tribunal.
No, I say plus because only if you also direct immediately within 2 days I will report the first installment because time is there, Milord. Not that time is over. I am saying that Milord, time extend the time. Time is till December. I can clear the dues within December, Milord.
No, the e-auction sale notice indicates that this was fixed for
5th, Milord.
5th of
12.
e-auction ସେଦିନ ଦେଇଛନ୍ତି ସେଇଦିନ e-auction ହବ. So if you deposit, then they what they used to do, they cancel this e-auction.
Let my friend take instruction. I will deposit the amount within
But
2
you are
days.
not prepared even to give a copy of the writ petition.
ମୁଁ ଜାଣିନି
What
ସେ
instruction you will take?
ଏବେ କହୁଛନ୍ତି ବା ମୁଁ ମନା କଲି କପି ସାଙ୍ଗେ ସାଙ୍ଗେ ଦେଇଦେବି.
He has instruction to appear.
Yes, he could have.
Along with your copy of writ petition, pay the money.
I'm saying that.
Pay the money, then he'll consider.
Yes, you lost my
First installment you pay.
The Land and Council, you give your name, submit that he has instruction to appear for the Punjab National Bank. Let a copy of the writ petition be served on the Land Council for the opposite party. Submits the Mr. Samantra Land Council petitioner submits that even though he is aware that the alternative remedy is available to the petitioner to challenge the e-auction sale notice, but since the petitioner is ready and willing to clear all the dues of the bank and the auction sale notice, auction date is fixed to 5/12/2025. The matter may be taken up next week so that in the meantime you will approach the bank for negotiation.
That's how negotiation can. I will deposit also indicate I will deposit 67 lakhs
and
within 2 days.
I will deposit. No, I will not fix any amount.
No, first installment as per their
Upfront amount you have paid. Upfront amount you have paid.
Yes, 30 lakhs they have. You lost. That's why saying let's pay 23.
And
30 lakhs I have paid.
And they comply the terms of the OPS.
Yes.
And in view of submission, this matter on December.
Yes.
2025, both the Land and Council shall apprise this court about the development made.
No.
Yes, ma'am.
Item 11.
Yes, Mr. Mahanti. No one appears.
No, before we want.
Have you filed your appearance notice?
I'll find a Wakala now.
We give your name so that we'll answer. Like non-appears for the petitioner. So on to submit that he has instruction to appear for the
1 to 3 months.
All the opposite parties. Let him file the Wakalatnama and the matter will be listed. If in the meantime any Wakalatnama is filed by the Land Council, the same shall be placed on record and the name of the Land Council will be reflected in the yes, 15th on the bar purchase. Yes, next.
Item 12.
Please, this is judicial appointment matter. Petitioner has challenged the appointment of opposite party number 2 as a clerk from typist under the Sundargarh Justice.
On what ground?
Grounded matter, the certificate she has submitted as the old certificate. She claims to be in SCBC category and she has submitted the certificate of SCBC category as she was while she was a student.
Well, if the petitioner is challenging the certificate, then it will go to the miscellaneous, as per miscellaneous certificate, that court, my lord.
No,
Here the petitioner challenging the selection.
Selection, yes. Selection on the ground of certificate. Because it is judiciary appointment. And the Honorable Chief Justice has already...
Selection on the ground that the merit list was prepared, total taking into the all the candidates, my lord. There are
how many candidates appeared in And when the selection was made?
Election was made in the year, my lord.
Mr. Naik, you are appearing for the respondent of 1.
My lord.
2015.
My lord.
So there is a panel now, a good panel. Panels, changing, but has to be seen.
Annexure 1 is the notification, my lord.
Who is appearing for this opposite party number 2? You are appearing. So, Mr. Naik, panel has been formed
Yes,
by the.
yes.
So,
This year time, I don't have any. Then panel should go.
no, the registry shall give the instructions whether from that panel the council is to be engaged or you can.
You will continue.
I will let her.
That's that problem. You obtain that instruction
My
from
lord.
the registry
My lord.
and get it clarified so
My
that
lord.
we can take up this matter next week. Let me do the land council for the petitioners, also the land council for the opposite party that is present. Since in the meantime, a panel has been formed to represent the registry of this court. The land council for the state seeks some time to obtain instruction as to whether any council from that panel is to be engaged for the opposite party number 1 or not. Put up this matter. Next week. Let this matter on 3rd December 2025. Yes.
Item 13.
One time may be given for filing the
Why? As per the order dated Mr. Tripathi. Where is Mr. Tripathi?
Yeah,
You are there. Mr. Tripathi has filed further affidavit of this one, so wherein it is stated that it is actually submitted that in view of the above mentioned orders of so on so further due to paucity of funds and so on, disburse of the area dues relating to the revised scale of fees to the petitioner as well as to the other retired employees of the OSRTC. The amount involved is huge beyond your charge. The Land Council also made a request to hear the matters on merit. So that is now the matter is to be heard on merit. So the writ appeal has been previously filed challenging the order of the land single judge. So is a common order was passed in all these.
Yes, sir. Yes.
So when you want it,
In fact, my lord, I am appealing on behalf of the intervenor. Your lordship asked me that you wait and you will be given opportunity. If you allowed it, will problem for us. No.
Please tell us when you will argue the matter. See, the intervention application we consider, but what about you? When Mr. Tripathi will argue the matter?
Article of December.
Into December, please.
15.
All the retired employees are not getting anything.
No, it's all right. This matter is pending, but since there was a proposal for settlement and the instruction was sought for, that actually caused the delay. And an adjournment has been sought for on behalf of Mr. Amitabh Tripathi, the land council for the. You are for the
Respondent.
Land council for the respondent. No objection to the same. This matter on 15 of 15.
I have prepared a short circular and also few documents I want to produce. If your lordship will permit, then
once your intervention application is allowed, we will see.
Your lordship has asked me that you wait and you will be given opportunity of hearing.
Once you find that on that day, we find that. Yes. Item number 14.
Item 14.
Mr. Patnaik.
Interpretation press for questioning of the order of the OSFC on the section 29 miler and annex to 10. Reading is complete and filing a written note of submission on that case miler.
What is your prayer in this writ petition?
You set aside annex to 10 requires annex to 10 miler.
What is that annex to 10?
And the order of the State Financial Corporation section 29 of the SFC Act to take our position of the unit on ground of default, which doesn't exist at all.
Oh, there is a civil suit was pending.
The civil has been, as per my instruction, that's for rendition of account. And same as in dismissal of default. Those who never filed in WS, just continued.
Now, the civil suit was filed by whom?
By the petitioner
Petitioner.
for rendition of account.
It's all right. Now, no, that chapter is closed.
Closed money. The applicant filed an amendment to delete that portion of the prayer money.
Okay, so why this order would be quashed? What is your point?
My-
This annexure 10 you want to quash
Yes, my lord.
on what ground?
That there's OTS allowed in my favor. I paid that amount.
Where is that OTS allowed and how you say that you have complied with the order which was passed in the OTS? In spite of that, they have taken
Okay.
recourse to 20.
Annexure 1, my lords, page 13. That is OTS. Affidavit. Page 13. Subject your application for settlement of term loan and cyclone loan.
No, Mr. Patnaik, just show that portion of your averment taken in the writ petition that in spite of compliance of that OTS deposit of the OTS amount in time, still then they have taken recourse to this 29. Where is that? Let us see, and we will see that obviously the counter affidavit which has been filed. Just to come to that paragraph.
Date there is a written note. Date chart আছে.
Date chart কোন মানে আর averment non is like a date.
হ্যাঁ, averment.
Date averment আছে কোন আছে collection. You have mentioned that you submitted an OTS application.
Yes, my lord.
And that was considered by the corporation.
And approved. And I paid accordingly.
But what is that you have paid accordingly? Is it a case?
No, my lord, that was cancelled. And cancellation was challenged
Cancelled.
before this put in the writ petition, my lord.
No, no.
OTS ଆପଣ accept କରିକିନି cancel କଣ ପାଇଁ କଲେ?
Did not pay according to the terms and conditions.
That is why we are.
And that's my lord challenge before this honorable court in earlier writ petition.
What is that number?
And that is my lordship. I have filed the counter B by 1. Order dated 29/9/2011.
54, my lord.
Ultimately, what has happened in that writ petition?
Writ petition, lord, this honorable court was pleased to quash the notice under answer 7 series and direct the petitioner shall pay the OTS amount, settlement amount with interest 13.5%.
So again, it back to same position with
Yeah.
interest. What happened then?
So they did not pay within the
I
stipulated
paid, my lord.
period.
That is wrong.
No. They
I
have
paid.
also mentioned it.
I filed all the annexures.
And if
My
the
kindly
same-
go through the order
if
itself.
the same is not paid within stipulated period,
Yes.
Mr. Patnaik, now you show that you have earlier
steps.
approached and the order has been passed in your favor.
Yes, my lord.
That you are to deposit this amount with this interest.
Listen. And I
That
deposited.
stand taken that as per the order of
Yes,
this
sir.
court
Yeah.
in the earlier writ petition, you have cleared the dues in time.
Then and there, instead coming to this honorable court, they approve the civil court.
Para 12 miles. Para 12 of my expedition. Page 7. Now the petition being aggrieved with highly illegal and motivated actions of opposite parties has moved this honorable court in WPC no 25615 of 2011 with a prayer to direct the opposite parties to allow the petition to settle the dues of the unit under the OTS scheme, that is MFD OTS 707 scheme term loan, and allow the petitioner for payment of balance amount towards OTS and the Honorable High Court of Orissa after taking into consideration the fact and situation of the instant case and after hearing both the parties, by its order dated 29/9/2011, has been pleased to quash the notice under dated 13/9/2011 and directed that the petitioner shall the pay the OTS amount with interest of at the rate 13.5% per annum from the period of for the period of default
within a period of 3 months. Since the operative did not intimate the petitioner regarding balance settlement, the OTS as per the direction of the court, the petitioner in due obedience to the direction of the Honorable Court has already deposited 1,60,512 on dated 28/11/2011 towards a full and final payment of the withheld amount as per the calculation. That is Annex 6, my lord. My turn to Annex 6.
Just a minute. So this particular statement which they have made in paragraph number 12 is that as per the order of this court, they have deposited and an amount of rupees so and so towards full and final payment of
Not
the
full and
default.
final.
No, what is your stand taken?
Yes,
on
my lord.
counter?
They've also admitted in page
No, page
32,
23.
my lord.
Huh?
Page 32, my lord, kindly see.
In the writ petitions.
No, that's the page 32 in the writ petition.
Yeah.
That's this. So the para 21. Cause of action
pardon,
arose
I
on
mean, pardon, my lord.
28/11/2011 when the plaintiff approached the defendants for settlement of the financial paid a sum of 162,512. The defendant number 3 by the letter 23/12/2011 intimated the plaintiff that out of total balance of settlement amount with the delayed period interest, that 2,30,292, the plaintiff is required to pay differential amount to 67,780.
Okay.
That's she did not pay, my lord, within the stipulated period. And the High Court
The delayed payment has not been.
Yes, my lord. That's the
Notice
that
someone has
that
already
was
paid,
the
my
order.
lord.
And the specific order was if they failed to pay, then we said liberty to take action, and we have taken action. They approach the civil court. Then and there approach the civil.
So the
court.
question is about that non-payment of the differential amount of
Yes,
rupees
For
67,000.
delayed interest, my lord.
No, ठीक है जी.
Since
May I kindly come down to Annex 6 issued by OSFC at page 23, my lord. Annex 6. In inviting reference to the above subject, this is to inform you that you have deposited sum of rupees 1,62,512 by a check at the number towards prior payment of balance settlement amount and delay period interest. It is to inform that your term loan account are settled under MFD OTS 07 scheme at the rupees 12 lakhs which you have paid. Term loan paid, my lord. Your cyclone loan amount was settled at with 20 lakhs 57,000 under MFD scheme, out of which you have paid only 19 lakhs 35,539 as on 30/7/2011. Here, my lord, I may humbly submit that this 19 lakhs 35,000 plus 1,60,000 have referred above. I have already paid. The damage that I have received.
But some amount.
That is High Court order.
Delayed payment is not paid. That's all.
But as per the order of High Court, you have not paid. That's the question of I represent.
Because in the order of the Honorable Court, this court, there was a specific direction also that if you did not pay that amount in time, then the
Legal action to take.
so they have demanded. So why?
Yes, so my pleading is that, my lord. I repeatedly requested them to intimate, to give me a detail of the calculation, my lord.
ଦେଇଛନ୍ତି ପରା ଏଇଟା?
ନାଇଁ ନାଇଁ ଆମେ ଫାଇଲ କରୁଛୁ ଏଇଟା ଦେଲେ ପଛରେ ତାପରେ କଣ ହେଲା ଆମେ ତ ଫାଇଲ କଲୁ rendition account to know the exact position how much they pay. They never intimated, but this is also wrong. They said I have not paid the cyclone amount.
Suit was filed in
The cyclone amount already paid, term loan paid, only part of delayed period interest.
No. That's confusing, my lord. Because the term loan was paid, but did not pay the additional term loan. Did
I
not
never
pay the second
not additional term loan,
Did
the
not pay
cyclone
the
loan.
Cyclone loan outstanding. The
Paid.
settlement amount was
20 lakhs.
57,000.
Right, we'll take up day after.
Yes.
No, sorry, man.
Huh?
One day, man.
You are not there.
I'm not.
Mishra, Land Council for the petitioner files a date cap, which is taken on record. Copy of this time has been served on the Land Council for the opposite party. On the request of the Land Council for both the parties, the matter be taken. एक तारीख अपन चाहूँगा.
एक 3 anything in the convenient.
हाँ?
एक और 3 जोन convenient.
Okay, then 3rd of December 20.
So that's I beg your pardon. Just to be fixed matter also.
Who took it?
Third ଟିକେ ଅସୁବିଧା ଅଛି
You can
Either first or
fifth for them.
Yes, Miller, item 26.
Item 28, my lord. They have not yet filed their counter, my lord. Item 28 filed.
My lord, 26 will. There was a
ଗୋଟେ ଗୋଟେ କହିଲେ ହବ ନା
my lord.
ଆଚ୍ଛା ଲେଡିଜ ଫାଷ୍ଟ କୁ ତେଣୁ
Miller, I
28 ଆଗେ ନବା ହଁ କୁହନ୍ତୁ ମ୍ୟାଡାମ yes Mrs. Sigdar କୁହନ୍ତୁ
They have not the counter.
ପାରି ବହାରି ନାହାନ୍ତି ପଳେଇଲେଣି
I will intimate it, my lord.
Oh, Mr. Maharana, you are there so oh no
I
Mr.
am 29.
Samantha so you have to
That
file
day,
the
madam.
counter affidavit. We
Yes,
are
yes,
granting you some more time to
Yes.
file the counter affidavit.
That they specifically order that they will file counter.
Mrs. Rakesh Siddhar and counsel for the petitioner is present. And she submits that in spite of the specific order of this court,
Yes.
counter affidavit has not been filed. Mr. Maharana and senior panel counsel appearing for the Union of India submits that he will intimate Mr. Padi.
My knowledge is there, man.
Mr. Padi,
Yes, ma'am.
you have not filed the counter affidavit. Mrs. Sigdar is raising a serious objection to that.
Item 2.
So now today is the Constitution Day, so you must.
Definitely will take care of
effective.
yes.
So, how much time it required?
2 weeks time, ma'am.
All right.
Well, accepting 9 December.
Just
Accepting 9.
Mr. Aril and Deputy Solicitor General submits that 2 weeks time may be granted to file the counter affidavit.
Accepting 9th, madam. 9th.
Except
9 December.
No, 9th will not keep. We are keeping it on 15th of December. 15th of December.
Yes. Sir, may I copy to me, my lord?
Obviously, the
Definitely. The concerned council is
next item on the 29. So there is fresh admission and a notice has not been issued. That is wrongly listed in the up to notice admission.
Mr. Roshan.
Directed to serve a copy.
That will in the course of the.
No, is it correct, Mr. Rotho, that in this matter notice has not been issued?
First case, my lord, I have already filed
Notice is issued and the notice.
Notice has not been.
So if you have filed the counter affidavit, we are regularizing it, and then so that like on the issue notice on the question of admission, indicating that the matter shall be disposed.
Your Lordship may not entertain this application because it is covered by the Supreme Court judgment.
You have already filed the counter affidavit. We are mentioning.
The counter
affidavit has already been filed. The matter may be listed in the week commencing 15th December 2020 for final disposal.
In the meantime, my friend may be requested to take the adjournment in the contempt.
The counsel for the Union
has
pointed out that a contempt proceeding is pending before the London Tribunal. Since the final disposal of this matter is posted to 15th of December 2025, the parties shall not insist for progress of that contempt proceeding till next date. Yes, next.
Item 22.
Serve the copy. No
This
issue.
party has retired since 11 years.
Yes, sir.
Item 26. There was a direction from my lord from the bank side to file the counter.
Mr. Acharya is not there.
My lord, the bank counsel was there. Mr. Mahapatra, Delhi Maharaj. He stated and they will file the counter. We will file the rejoinder. Thereafter, matter will be taken up and interim order is continued till today.
Previously counter file na presence
Are
you appearing for? So what time you require to file the counter?
1 week.
1 week. Mr. Kunasal and counsel for the petition is present. You are appearing for Acharya?
DK Mahapatra.
From the State Bank of India. Number 1 and 2.
The land counsel so and so appearing for Mr. Dilip Kumar Mahapatra, counsel for the bank, submits that the counter affidavit will be filed within 1 week. List this matter. Copy of the counter affidavit is served on the land counsel for the petitioner. If the land counsel for the petitioner seeks to file any rejoinder affidavit, the same shall be filed in the meantime. 3 सप्ताह पर entry model check. Yes, entry model check करिए.
Item has been 22. I'm sorry.
Just a minute.
Obliged me.
Yes.
22.
22, what do you want?
My lord, the petitioner,
You are for the opposite party.
Yes, my lord.
Who is for the bank? A state of Odisha. He's not there. Why are you making mention?
My lord,
It has all the counter affidavit has already been filed.
Yes, ma'am.
So it is, and you have not filed they have not filed the rejoinder affidavit. But it is to be now taken up for final disposal. Counsel is not there. Why are you making mention?
Only to fix it.
This matter will come on Friday. Why are you making mention today? Yes, next.
Item number, may I pray when the senior is there, both of us, Lord should collect next week, any day.
15.
15, item.
କେବେ କହୁନାହାନ୍ତି କଣ?
Any day, Lord, third, fourth, second, so yeah, ଯେବେ ଆପଣ choose,
କେବେ ରଖିବ ଆପଣ?
any day, Lord, third, fourth.
I was asking next week any day because he has some inconvenience.
ସୋମବାର, ବୁଧବାର ଆଉ ଶୁକ୍ରବାର ହିଁ ରହିପାରିବ। ତେଣୁ ଯୋଉ ଡେଟ୍ ଆପଣ ମାନେ କହିବେ ରଖିବେ।
Because he has some inconvenience, let it fix up the date. I'm ready.
On consensus of both the parties, like Mr. Russell and Senior is present, Mr. Patnaik and counsel for the. You are appearing for whom?
I'm the respondent, madam.
For the respondent.
Opposite.
8. List this matter on consensus. List this matter on 8th of December 2025. Yes.
Lord, two applications for bail and one fresh application criminal law.
No, pardon, madam. Item 34, madam, 2 days list. I filed an interim bail for as the mother of the petitioner died on 18 May. Tomorrow is the Thursday. The candidate.
Already there.
Which is that item?
34, madam.
34. What is the IN number?
3196 of 25.
ଫୁଲ ସେ ଆଇଏ ଜାଗାରେ ଏଲେ ଲେଖି ଦେଇଛନ୍ତି ସେଥିରେ କରେସ୍ପଣ୍ଡେନ୍ସ ରେ ଆଇଏ ଜାଗାରେ ଏଲେ ଇଣ୍ଡିକେଟ କରିଛି
Item number 3196 of 2025 is an application for interim bail on the ground of death of the mother of the petitioner. And it is stated in the application that the petitioner has to perform the obsequious ceremonies of his deceased mother, and therefore his presence in the village is necessary, in the house is necessary. When the matter was taken off, Asha, when a mention was made, we asked the London Council for the state to give an instruction on the interim application. Today, the Land Council for the state has produced the written instruction dated 25/11/2025 from IIC, Aska Police Station, which shows that the mother of the petitioner expired on 18/11/2025. The written instruction is taken in record, considering the submission made by the Land Council for the respective party, the government's taken the interim application to written instruction obtained by the Land Council for the state. We are inclined to release petitioner for a period of 15 days on the date of release. Put of this matter on such and such date, the Land Council for the appellant shall file the surrender certificate.
Copy in court supply here.
Mr. We have asked you that ensure the appearance of DG presence.
already implemented
Has he appeared?
join.
Ask him to join. Just make a contact so that we can take up this matter. In his presence, we'll take up this matter. We are going serially, but once he joins, we'll take up. Yes, call the matter.
Supplementary Delhi, second up, item number 1.
What is this appeal for? Life is living. But I need for the trial court record engine of for freedom stabilization of time. To be considered after the charge of the Land Council for the appearance will supply the deposition copies of the witnesses examined the Land Council for the state. Yes, next.
Item 2.
Madam, you have filed a delay condonation application.
There is no delay for us, sir.
Listen. IN number 304025. An application filed for condonation of the death. But since the stampede photo has pointed out that there is no delay in filing the criminal appeal, the Land Council for the appellant doesn't want to press the application. Accordingly, interim application is disposed of as not pressed. But here's a condition to
Provision for life and file
Under section
376 2N
364, 302, 201 and 34 IPC.
rest of the order like the previous one. Yes. आज ऐसी जाए
नहीं जानी there is a connection.
Who to them?
In item 4 also his presence is required because the convicts had escaped and those are
No, first we'll take up this item number
16.
16. So for that, yeah. And what about the,
Ajay.
okay.
Yeah.
Yes.
Good afternoon, sir. This is Sushant Nath, sir, DG Prisons.
Please, we are taking up one matter. Just as per the as per the order dated 24/11/2025, the superintendent has reported that after thorough search in the CIS portal, it is found that only this case, this jail criminal appeal has been filed on 4/10/2025. Hello? Then we called for a report from the London District and Session Judge Baripada Moyurvanj as to why the impugned judgment was not challenged before this court by filing so and so, since regular inspection are being made to the jail, not only by the London District Judge but also by the officer attached to so and so. What happened to the madam, you are the secretary DRSA.
Yes, madam.
Have you verified the records to know whether the trial court record of the case, either in original or in digital form, has been called for by this court in connection with any criminal appeal or jail criminal appeal?
Yes, my lord, I have verified the records and the registers, but the trial court record has not been called for either in original or in digital form by the honorable court in connection with any criminal appeal or jail criminal appeal, my lord.
So now it is available in the
Record room, my lord.
huh?
The case record is available at the record room, my lord.
Record room. Record room. Madam, please tell your name.
What is your name, madam?
My lord, Rajashree Patnaik.
What?
Rajashree Patnaik.
Rajashree Patnaik. Ms. Rajashree Patnaik, Secretary DLSA, Moyurvanj Baripada, as per the order dated 24/11/2025, informed us that she has verified from the records that the trial court record of the case, either in original or in digital form, has not been called for by this court in connection with any criminal appeal or jail criminal appeal, and it is still available in the records room. Madam, we have also sent intimation to the learned district and session judge
Yes, ma'am.
Baripada as to why it was the impugned judgment was not challenged earlier before this court by filing CRLA or JCRLA, since regular inspection are being made. So the district judge has to submit that report, but he has not submitted the report. What is your instruction on that? The 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 order has already been sent by the register judicial.
Yes, ma'am.
So intimate your district judge and
Yes,
ask him to submit the report during course of the day, so
yes,
that
ma'am.
we can incorporate. You
Yes,
are
ma'am.
aware of the order and just ask the district judge immediately after this matter is over
Yes, ma'am.
that to submit the report. Okay.
Yes, ma'am.
Okay. Now we are asking this jail superintendent, Circle Jail Baripada.
Sir.
So, Mr. Jail Superintendent,
Sir.
did you been able to contact with the council?
Yes, sir.
You is stated to have preferred any appeal or jail crime, whatever it may be.
Sir, I have already contacted the council. He has the accused, the convict has engaged. Yesterday, last evening, he had come to the jail office, and the convict has talked to him, sir. And he has told me that he has not preferred the appeal on behalf of the convict, sir.
तो कौन सी अपील फाइल ही नहीं? He is not filed.
Nice, sir. से करना है, sir.
Acha, all right. As per the order dated 24/11/2025, the jail superintendent, Circle Jail, has ensured the appearance of the appellant through virtual mode and submitted that the counsel of the appellant was contacted, and he stated that he has not preferred any criminal appeal of the appellant before this court. Stop. So now, Mr. DG of Prisons,
Good afternoon, sir. This is Sushant Nath, DG Prison here.
Sushant Nag. Mr. Nag, this is a jail criminal appeal, and the number is 183/2025. The appellant is one Jatia Hembrown, and he faced trial in the court of additional session judge Baripada for offence under section 302 IPC, and on 31/2013, January 30th, 2013, he was found guilty under section 302 IPC and sentenced to undergo imprisonment for life. Now, when this appeal was filed through jail in 2025, the staff reporter pointed out that there is a delay of 4, 5, 6, 5 days. So, when the matter was taken off on this 24/11/2025, day before yesterday, so we not only ensure the appearance of the appellant, the jail superintendent, any problem? Are you able to hear us? You unmute yourself. First unmute. Yes. Mr. Nag, are you able to hear us?
right hand side to the top corner जे କହିବ ତା screen ରେ ଆସିବ sound type
Can you hear us? म्यूट ହେଇଗଲା
ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ
Yes, Mr. Nag, can you hear us?
ଆଉ ଗୋଟେ କମ୍ପ୍ୟୁଟର ଆଣିବି ନାଇଁ ଆଉ ଲାପଟପ୍ ନାହିଁ
ଅନମ୍ୟୁଟ୍ କରନ୍ତୁ
He is not able to hear us. Can hear him.
Talk to him over phone and ask him that we are not able to hear him. What is this? DG prisons and जेल सुपरिटेंडेंट ना कौन आपनकर?
मनोरंजन प्रतिहारी सर।
लास्ट टाइम लिखा है
मनोरंजन प्रतिहारी। ए सर्कल जेल बारिपदा रे जेल सुपरिटेंडेंट हिसाब रे केबेठू अछंती?
सर सर मु सर 4 जुलाई से जॉइन कले 2025 सर।
2025
सर।
2005
सर
2005 means
2025
2025
सर 25
725
सर।
तो मैडम अपन डिस्ट्रिक्ट जज को इंटीमेट कले तो
सर सर को रिपोर्ट टा आ जाईची सर आस्ती सर।
जस्ट एटा लिखि दियंती that the Ranyan District and Session Judge Baripada, in pursuance of the order dated 24/11/2025, has submitted his report wherein it is stated that since his joining the District and Session Judge Marvanj Baripada on 15/5/25, irregular jail inspection have been conducted by him personally as well as by Secretary DLSA Marvanj. And during each such jail visit, all convicts are individually informed regarding their right to prefer appeals and are specifically inquired regarding filing of jail criminal appeals within the stipulated appeal period. Further, the Secretary DLSA Moyurbhanj has also been instructed to verify and report whether all convicts have preferred their criminal appeals before this court and to ensure that legal aid is provided promptly in all eligible cases. The Secretary DLSA has taken necessary steps for filing criminal appeals of the convicts before this court in odd cases where no appeal had been filed, as well as in cases where no data was available whether any appeal has been preferred. It is further stated that after this matter was brought to his notice, the appeal petition was forwarded to this court. To the Legal Services Committee of this court by the Secretary DLSA by later dated 29/2025 for providing necessary legal aid and assistance to the convict for filing the appeal. It is further stated that delay in filing the appeal in this case was not intentional, and the Lanyan District Judge has begged sincere apology for the unintentional delay occasioned in filing the appeal. He has assured in writing that he shall remain vigilant in future and shall take necessary steps to ensure that all the jail criminal appeals of the convicts are filed within stipulated period henceforth. The report is taken on record. Madam,
Yes, my lord.
ଆପଣ district judge ଲେଖିଛନ୍ତି ଯେ Secretary District Legal Aid Service Authority Moyurbhanj has taken necessary steps for filing the criminal appeal of the convicts before this court in all cases where no appeal had been filed, as well as in cases where no data was available whether any appeal has been preferred. এই দুইটা ভিতରୁ এই যে particular কেসটা কাହା ভিତରେ ଆସିବ? এই କେସରେ ଆପଣ ତ appeal ଜେଲରୁ appeal ଫାଇଲ ହେଇ ନଥିଲା, ତେଣୁ ଆପଣଙ୍କ ପାଖରେ ଡାଟା ନଥିଲା ଯେ appeal ଫାଇଲ ହେଇଛି କି ନାହିଁ, ତ ଆଗରୁ କଣ ପାଇଁ appeal ଫାଇଲ ହେଲା? You are there as the DLSA secretary since when?
30 January 2025.
30 January 25. So it could have been filed earlier. And Mr. Pratihari,
sir,
ये गोटे केस है we are going in that.
sir,
ये जो केस रे आपण हमकु पहर दिन कहिथिले डे बिफोर यस्टरडे,
sir,
that appellant कहिला जे से अपील ପାଇଁ ଫାଇଲ କରିବା ପାଇଁ ଜଣେ ଓକିଲଙ୍କୁ ଦେଇଛି, ସେଇଥିପାଇଁ ଆପଣ ଜେଲ କ୍ରିମିନାଲ appeal ଫାଇଲ କଲେ ନାହିଁ। ତ ଏଇ ଟାଇପର ଯଦି ଆଜି ଦେଖିଲେ ତାଙ୍କର ଓକିଲ ବାବୁ ଜଣେଇଲେ ଯେ appeal ସେ ଫାଇଲ କରୁନାହାନ୍ତି, ତ ଏଇ ଟାଇପର କେସେସ୍ ମଧ୍ୟ ବହୁତ ଏକ୍ସାମ୍ପଲ୍ସ ଆସିବ। ତେଣୁ ଆପଣ ଯେତେବେଳେ ଜେଲରେ କୌଣସି କନଭିକ୍ଟ ଆସି ରହୁଛନ୍ତି, ଆପଣ ମାନଙ୍କର ଦାୟିତ୍ୱ ହଉଛି ଯେ ସେ ତାର ପ୍ରାଇଭେଟଲି ତାର ନିଜ ଓନ୍ ଆରେଞ୍ଜମେଣ୍ଟରେ appeal ଫାଇଲ କରୁ, ଯଦି ତାର ଫାଇନାନ୍ସିଆଲ କ୍ୟାପାସିଟି ନାହିଁ ତାହେଲେ ଲିଗାଲ ଏଡ୍ ଜରିଆରେ appeal ଫାଇଲ ହବ, ଏବଂ ପ୍ରତ୍ୟେକ କନଭିକ୍ଟର appeal ନମ୍ବର ଆଉ ତାର କାଉନସିଲ କିଏ, ତାଙ୍କର କଣ୍ଟାକ୍ଟ ନମ୍ବର, it should be mentioned and in the jail record itself. ତେଣୁ ଆଜି ହିଁ ଭେରିଫାଏ କରନ୍ତୁ ଆପଣଙ୍କର ବାରିପଦା ଜେଲରେ ଯେତେ ଜଣ କନଭିକ୍ଟ ଅଛନ୍ତି ତା ଭିତରୁ ସମସ୍ତଙ୍କର appeal ନମ୍ବର ଆପଣଙ୍କ ପାଖରେ available ଅଛି ନା ନାହିଁ। ଯଦି କୌଣସି appeal ନମ୍ବର ନାହିଁ ଆଉ ସେ appellant କହୁଛି ଯେ ମୁଁ ପ୍ରାଇଭେଟ ଆରେଞ୍ଜମେଣ୍ଟରେ appeal ଫାଇଲ କରିଛି ବୋଲି, ତାହେଲେ ସେ ଜେଲ appeal ସେ କ୍ରିମିନାଲ appeal ନମ୍ବର ascertain କରନ୍ତୁ। ସେ ଯଦି ଜାଣିଛନ୍ତି ଭଲ କଥା, ନହେଲେ ସେ ଯଦି ଓକିଲଙ୍କ କଥା କହିପାରୁଛନ୍ତି ସେ ଓକିଲଙ୍କ ଜରିଆରେ ସେ କ୍ରିମିନାଲ appeal ନମ୍ବର ascertain କରନ୍ତୁ। ଦ୍ୱିତୀୟ କଥା ହଉଛି ଆଜିକାଲି ହାଇକୋର୍ଟ ୱେବସାଇଟ ଖୋଲିଲେ ସେ କ୍ରିମିନାଲ appeal ଯୋଉ ନମ୍ବର ଆପଣଙ୍କ ପାଖରେ ଥିବ available, ସେ କ୍ଲିକ କଲେ ଜଣା ପଡିଯିବ ଏଇଟା ସେଇ ଲୋକର appeal କି ନାହିଁ। ତାହେଲେ ଗୋଟେ ଅଥେଣ୍ଟିକ ଇନଫର୍ମେସନ ଆପଣଙ୍କୁ ହାଇକୋର୍ଟ ୱେବସାଇଟ ରୁ ବି ମିଳିଯିବ ଯେ ପ୍ରକୃତରେ ଏଇ ଯୋଉ ଓକିଲ ବାବୁ କହୁଛନ୍ତି ଏତିକି ନମ୍ବର appeal ତାଙ୍କର ବୋଲି ସେଟା ଠିକ କି ନାହିଁ, ହେଲା। ତେଣୁ ଜେଲ କ୍ରିମିନାଲ appeal ହଉ କି କ୍ରିମିନାଲ appeal ହଉ, ସବୁ କନଭିକ୍ଟଙ୍କର କେସ୍ ନମ୍ବର ଆପଣଙ୍କ ପାଖରେ available ଥିବ, ହେଲା। ମିଷ୍ଟର ନାଗ, ଏଇ କେସରେ ଆପଣଙ୍କୁ ସେତେବେଳେ କହୁଥିଲୁ ଆମେ, are you able to hear us?
Sir, sir. Sushant Nath, sir, DG prison, sir.
Acha, DG prison. So, what has happened in this case, the appellant Jatia Hembram, he was found guilty by the trial court, that is Additional Session Judge Baripada, and the judgment was pronounced on 31/2013.
Sir.
He was found guilty under 302, sentenced to life imprisonment.
Sir.
Now, some impression was given perhaps by him that I will file the appeal on my own, and I have also entrusted the brief. So that is perhaps the reason why the jail criminal appeal was not, no step was taken. But ultimately, perhaps it came to the light that he has not preferred any appeal. That is the reason why this jail criminal appeal was filed in the year 2025.
Sir.
And the stamp reporter has pointed out that there is almost 12 and a half years, more than 12 and a half years delay in filing the jail criminal appeal.
Sir.
So we have called for the reports and we have ascertained from him as well as the jail superintendent, and the district judge has submitted a report. Now, what we want as a Director General of Prisons,
Yes.
that since in many cases, not only in these cases, but whenever jail criminal appeals at least are coming, in some of the cases it is coming to our notice that there is inordinate delay in filing the appeal, and that will for a life convict.
Sir.
Okay, so what we want you to do, you collect the data
Right, sir.
from all the jails in respect of the convicts.
Sir.
And see that whether they have preferred the appeals or not.
Sir.
And if the appeals have been preferred, then the jail criminal appeal or criminal appeal number, the counsel name, the contact number, if it is available, that should be mentioned in that report. If it is not available, then you instruct the jail superintendent that they, with the help of that convict, they should collect it and submit a report to you.
Sir.
Right?
Do you have a centralized database on this aspect?
Sir, if I can come to the background of this, ମୁଁ ଏବେ sir ମେ ମାସେ ଯେତେବେଳେ ଜଏନ୍ କଲି ସେଥିରେ ଜଷ୍ଟିସ ସୂର୍ଯ୍ୟକାନ୍ତଙ୍କ ଗୋଟେ ଭିସି ହେଇଥିଲା sir, ଯୋଉ କେସ୍ ରେ ଲାଇଫ କନଭିକ୍ଟ ହାଇକୋର୍ଟରୁ ସେମାନଙ୍କର ରିଜେକ୍ଟ ହେଇଯାଇଛି ଏବଂ ସୁପ୍ରିମ କୋର୍ଟରେ ତାଙ୍କ ଏସଏଲପି ଫାଇଲ ହେଇନି, ସେ ସମସ୍ତ କେସ୍କୁ ଆଉଥରେ କଲେକ୍ଟ କରିକି ପଠେଇବା ପାଇଁ ଆମକୁ ଡାଇରେକ୍ସନ ଆସିଲା sir, ଚିଫ ଜଷ୍ଟିସ ନେଇଥିଲେ sir ସେଟା। से डायरेक्शन हिसाब रे आमे चीफ जस्टिस को डायरेक्शन हिसाब रे आमे गोटे स्पेशल ड्राइव करिकरी जो मानकर हाई कोर्ट रु रिजेक्ट हितिला बेल सॉरी अपील एंड सुप्रीम कोर्ट रे फाइल करि पारि नथिले से समस्त केस को कलेक्ट करिक सर को बनि थिवो सर, आमे गोटे कंपाइल करि पठैथिलु एवं से सब गोटा प्रोसेस हि सब जाई कि सुप्रीम कोर्ट रे फाइल।
Similarly from sessions court also you have to do it.
Similarly at that time sir justice sir निजे ही मते कहितले मुझे पर्सनली देखा करथिली गोटे आमर जो माने हाईकोर्ट रे अपील फाइल करि पारि नांती तांको पई गोटे स्पेशल ड्राइव करिया पई कहितले आमे से जुलाई मास रे ही से मास क्षेत्र करथिलु सर, से तारो ऑफशूट रे एई लोकर फाइल हेछि वर्तमान जोटा क्रिमिनल अपील फाइल हेछि अंडर दैट प्रोसेस सेत्र आमे 150 ना केते केस आमे फाइल करथिलु सर, जो मानकर आगुरु कोनोसी रेकॉर्ड नथिला जे से माने हाईकोर्ट रे फाइल करचंती ना नाही एवं आम पाखे रेकॉर्ड नथिला एवं तांको पचरा गला से माने कहला आमे कोर्ट वकील को लगैथिलु किंतु एपर्यंत आमे जानिनु फाइल हेछि ना नाही, सेही बेसिस रे आमे गोटे स्पेशल ड्राइव करिकरी सेतबेले ए लोकटा भी सेतबेले डिटेक्ट हेइतला सर, से हिसाब रे सेटर फाइल हेछि एई बळे हमरो पाखापाखि 150 केसेस रे सेमति फाइल हेछि इन द रिसेंट टाइम सर। एक्चुअली अमन को प्रोसीजर जहा जेल मैनुअल रे लिखाई सर, एट द टाइम ऑफ देयर एंट्री इनटू द जेल जेतबेले कन्विक्शन हेकि आछुंती से माने गोटे तांकर गोटे कागज रे एमति लिखा जाय सर, से माने सेतरे लिखि दियंती एट लिखि दिछि से निज हाथ रे जे मो निज वकील हिसाब रे काम करिबि सर। 2013 रे जेतबेले एटा हैला तापरे फ्रॉम टाइम टू टाइम ताकू पचारा जाइछि केउ से कहछि मोर वकील अछि से तार फाइल करछि, किंतु एमानकर फॉल्ट हैला तांकटो लिखित भाबरे किछि तांकर अपील नंबर कलेक्ट करा ही पारि नै। ए जो स्पेशल ड्राइव टा हमें जुलाई मास रे करू सर, सेथिरे हमर बहुत गुडे केस डिटेक्ट हैला, सेथिरे हमें ए क्रिमिनल अपील जेल क्रिमिनल अपील गुडा फाइल करछु सर थ्रू आवर डीएलएसए आल्सो गॉट इन्वॉल्व। डिस्ट्रिक्ट जज निजे आस्थिले सर जेल रे, ता भितरे भी केते जण कहले जे हम अपील फाइल करिवु नाही, तांको बहुत परसुएट भी करा हितला। ता भितरे दुई जण बदे मते लागुची केउंझर जिल्ला रे केउंझर जेल रे भी दुई जण थिले जो माने परसुएट कला परे डिस्ट्रिक्ट जज निजे परसुएट करथिले, तथापि से माने राजी नथिले, आ जो माने राजी हितले तांकर समस्तकर क्रिमिनल जेल क्रिमिनल अपील फाइल करा हितला सर।
Now, since you have understood the real problem, where the problem lies, what are the solution you are proposing?
So solution sir, हमें आउ गोटे स्पेशल ड्राइव करिवु सर, सर को जदी सर को डायरेक्शन also, and we will find out jahara record against criminal appeal number nahi ସମସ୍ତଙ୍କୁ ଆଉ ଥରେ ଆମେ persuade କରିବାକୁ ଚେଷ୍ଟା କରୁ ତମ ଯଦି କିଛି ଅଛି appeal private appeal ତମେ number ଦିଅ ଯଦି ନାହିଁ over and above that ଆମେ ଆଉ ଥରେ ତାଙ୍କର jail criminal appeal file କରିବା ପାଇଁ propose କରୁଛୁ sir.
No, another thing you do, ଆପଣ ମାନଙ୍କ ପାଖରେ ଯୋଉ ନମ୍ବର ବି ଅଛି ଯୋଉ କ୍ରିମିନାଲ ଆପିଲ କହୁଛନ୍ତି ବା ଜେଲ କ୍ରିମିନାଲ ଆପିଲ ଆପଣଙ୍କର କାହାକୁ ଗୋଟେ ଏଣ୍ଟ୍ରଷ୍ଟ କରନ୍ତୁ ପ୍ରତ୍ୟେକ ଜେଲରେ ବା ଆପଣଙ୍କ ହେଡିଂ ରେ ଡିଜିପି ଆପଣ ଯେ ପ୍ରକୃତରେ ସେ ନମ୍ବର ଆଉ ସେ ଅପିଲ ଗୁଡାକ ତାଙ୍କର କି ନାହିଁ that can be verified easily if someone opens the High Court website जो अपील्स नंबर आसीबो एंटर कर दे चली गले से ना आसी जाउची तांकर एवं को जजमेंट अगेंस्ट रे से माने फाइल करचंदी को थरे एगुडा सब डाटा चली आउची तेणु ऑथेंटिक नंबर ए जिनसडा पाई जिवे जे क्रिमिनल अपील ए जो नंबर आनिकिनी से जने वकील बाबू देइचंती तांकर अपेलेंट को और कन्विक्ट को दैट इज ए ऑथेंटिक नंबर से जिनस मध्य रहू
You can verify.
It should be verified and you are to also keep that name of the council, that is most important, name of the council au tankara contact number so that darkar पड़ले time to time एमानकु allow करंतु सेमाने contact करिवे to know about the progress of the appeal बा आपनकर इवन सुपरिटेंडेंट को प्रेजेंस रे सेमाने तांकु अलाउ करा जाऊ बा सुपरिटेंडेंट पचारि किनी निजे बुझी किनी तांकु इंटिमेशन दियंतु जे तो स्टेज बर्तन बेल एप्लीकेशन फाइल हेतला तारो रिजल्ट ला बा पेंडिंग अछि जहा भी हो तारो स्टेटस ऑफ द क्रिमिनल अपील should be communicated to the appellant from time to time तांकु मध्य गोटे आपण जेमती भुवनेश्वर जेल ले करिथिले जो मानकर अपील फाइल हेची तांकु देई दियंतु गोटे टाइप रो गोटे पेपर रे जे तांकर कन्विक्शन डेट होची या कोर्ट ना होची या तांकर कन्विक्शन या हला सेंटेंस या हला तांका अपील नंबर होची या तांकर काउंसिल को ना होची या कांटेक्ट नंबर होची या गोटे सीट रे सोडा तांको पाखे ही अवेलेबल थिबो सो दैट जेल रेकॉर्ड हो एवं पर्सनली जो माने कन्विक्ट अछंती तांको पाखरे गोटे गोटे सीट सेटा को आपण करिकिनी लैमिनेशन करिकिनी तांको दियंत ये गोटे कथा द्वितीय कथा होची आपण ए जो एबे रिसेंटली लास्ट मंथ रे गोटे डिसीजन हेची से जो स्पेशल ड्राइव कथा कहिले दे no one can compel the convict to file the appeals criminal appeals हला से माने बहुत कारण पई से माने होय तो अपील न फाइल करि पारंती से माने भाबथिबे जे जा ठीक हेची हमें अपील करिया चाहूनु बा से माने देखुथिबे जे सरी आसिलानी आउ ये हमें अपील करिया चाहूनु बा विभिन्न कारण नै तेनु तांकु तांकु गाइड करा जाई परिबो तांकु एडवाइस दिया जाई परिबो but you cannot compel them to prefer any appeal so that is the decision of the honorable Supreme Court last month re decision ta heichi so what we want you to do जो माने आपण कहउचंती जो कहले दीटा केस देले केउंजर रो जे से माने अपील प्रिफर करिया को चाहू नांती तो से टाइप रो जिंसटा इन राइटिंग तांकोटू नियंत and that too in presence of the district legal services authority रो जे secretary अछंती तांकर प्रेजेंस रे नियंतु एवं that should be forwarded to the our member secretary Orissa state legal services authority एवं तार गोटे ये मध्य जेल अथॉरिटी का पाखरे रहो राइट सो जेल अथॉरिटी का पाखरे रहले फ्यूचर रे सेटा काम रे लागिवो जेते बळे क्वेश्चन आसीबो जे कोन पाई सेठी अपील फाइल करा गलानी ताले सेठी देखै देबे से निजे इच्छुक नथिला इन स्पाइट ऑफ द परसुएशन और एडवाइस और गाइडेंस ही डिड नॉट चूज टू ऑप्ट टू फाइल एनी अपील सो सेटा को गोटे मेंटेन करते एवं तार रेकॉर्ड मध्ये हमर स्टेट लीगल सर्विसेज अथॉरिटी को आसीबो madam is there and this order will be passed today and it will be sent to you also through the London State Council. And
Sir, my only request, sir.
yes.
Sir, my request last time also ଆମେ DLSA ଙ୍କ ସହିତ ମିଶିକି ଗୋଟେ joint effortly ଆମେ ବଢିଆ special drive କରିକି ସମସ୍ତ document compile କରିକି DLSA through ରେ ପଠେଇଥିଲୁ sir.
But
So if
it's a regular process. It's a
again
regular
we'll do
process.
that in coordination with DLSA and the district judge sir. So ଯଦି sir ଙ୍କ ସେ ଅନୁସାରେ
ଆପଣ ଏଇ କେସ୍ ଟା ଜଷ୍ଟ ଏକ୍ସାମ୍ପଲ ଦେଖନ୍ତୁ ଏ ଲୋକଟା କନଭିକ୍ସନ ହେଇଛି 2013 ରେ ଆଜୀବନ କାରାଦଣ୍ଡ ହେଇଛି 2025 ପର୍ଯ୍ୟନ୍ତ କୌଣସି ଅପିଲ ଫାଇଲ ହେଇନି ହୁଏତ ଯଦି ସେତେବେଳେ ଫାଇଲ ହେଇଥାନ୍ତା ହୁଏତ ଆ ଭିତରେ ତାର ବିଚାର ସରି ଯାଇଥାନ୍ତା ବା ତାକୁ ହୁଏତ ବେଲ ମିଳି ପାରିଥାନ୍ତା କଣ ହେଇଥାନ୍ତା ସେତେବେଳେ ହେଲା କିନ୍ତୁ ବର୍ତ୍ତମାନ ଏଠୁ ଜିରୋ ରୁ ଷ୍ଟାର୍ଟ ହଉଛି ଅପିଲ ଫାଇଲ ହବ ଅପିଲ ଆଡମିସନ ହବ ତାପରେ पेपर बुक जो प्रोसेस सब अच्छी it will take some time so no one can give him or return back that 12-13 years which he has lost ତେଣୁ କୌଣସି ସିଷ୍ଟମ ରେ କିଛି ଲାକୁନା ରହିଛି ଯୋଉଟାକୁ କି ଆମକୁ ରେକ୍ଟିଫାଇ କରିବାକୁ ପଡିବ ତେଣୁ since you are holding such a position in which you can do so many things for this type of cases. So please look into it and we are passing the order, it will go to you. Hello? And madam, ଆପଣ henceforth coordinate କରିକିନି ଦେଖନ୍ତୁ ଯେମିତି maybe that magistrate ବା ଆପଣଙ୍କର order against ଯୋଉଠି even if district court को ହଉ ବା high court जो appeal file କରିବା କଥା it may be life conviction, it may be other single judges matter, but it should be filed immediately. And if they say that we will make our own arrangement, so that should also be pursued and it is to be ensured that the criminal appeal is filed. Sometimes the brief is handed over to the council and for some reason they might not file the appeal. ତେଣୁ ହୁଏତ appropriate instruction ଆସିନଥିବ ସେମାନେ ଫାଇଲ କରିନଥିବେ କିନ୍ତୁ କନଭିକ୍ଟ ର ଇମ୍ପ୍ରେସନ ଥିବ ଯେ ମୁଁ ତାକୁ ଦେଇଛି ଓକିଲ ବାବୁଙ୍କୁ ସିଏ ହୁଏତ ଫାଇଲ କରିଦେଇଥିବେ ତ ଏଇଭଳି ଅବସ୍ଥାରେ ରହିଯାଏ ଫାଇଲ ହେଇପାରେ ନା ଜେଲ କ୍ରିମିନାଲ ଅପିଲ ଫାଇଲ ହଉଥିବ ନା କ୍ରିମିନାଲ ଅପିଲ ଫାଇଲ ହଉଥିବ ତେଣୁ ଏଇଟା ଗୋଟେ କେସ୍ ଟା ଗୋଟେ ଗ୍ଲେୟାରିଂ ଏକ୍ସାମ୍ପଲ ଯୋଉଠି ଗୋଟେ ଲୋକଟାର 12 ବର୍ଷ ତାର ନଷ୍ଟ ହେଇଗଲା 12.5 ବର୍ଷ ନଷ୍ଟ ହେଲା କୌଣସି ଅପିଲ ଫାଇଲ ହେଇପାରିଲାନି so look into all these things and we hope that this should not be repeated in future बाकी जो अन्य केस गुड़ाक आपण जो केस रे कहउचंदी 100 केतेटा केस आपण डिटेक्ट कले जो थारे जे अपील फाइल ही नथिला ता धीरे जेल क्रिमिनल अपील ऑलरेडी फाइल हे गलानी
सेगुडा आमे सर पठीचु डीएलएससी के थ्रू रे तांकर सब कागज डॉक्यूमेंट देकी संको तांकर सिग्नेचर नै कि पठाइछि सर दे मस्ट बी कमिंग अप इन द कोर्ट सर
no we want that information आपण तार गोटे डाटा पठांतु से माने अपेलेंट कर एटलीस्ट ना गुडा को दियंतु आउ कन्विक्शन जजमेंट ये सब डाटा दे देले will verify that whether the jail criminal appeals have been preferred or not. Our secretary, High Court Legal Services Authority, he can check from the records whether in fact those jail criminal appeals have been registered or not. So once it has been registered, it will be communicated to the convict. कारण प्रत्येक जेल क्रिमिनल अपील आमे जेतोले काउंसिल मध्ये एंगेज करू तांकू गोटे कुहाउची जे ए सो इज एंगेज and the jail authority को intimate होची तांको काउंसिल करो ना जणे दबा हला so we are passing the order like that to see that in future this problem is sorted out hela
yes
thank you so far the recapture is concerned recapture is concerned the number of the prisoner is outside for leave so on that point
another thing which has also been brought to our notice
sir
that this prolonged leave which has been granted so that is the of course the discretion of the authorities the jail authorities and sometimes for some reason family thing or somebody's marriage, death, etc., they used to grant this prolonged leave. But in some cases, we find that after that leave period is over, they do not return to the jail. And uh, thereafter, the matters are being taken very casually. That means just a intimation is given to the police that so and so had such and such thing happened. And in some of the cases, they are roaming in the village freely. Those persons who have gone on leave for, let us say, 15 days, they are enjoying and roving in the village for 10 years, 12 years. Some examples have also come from that open jail, and steps are to be taken for early apprehension in those cases. So, how have you planned out all those things also?
Sir, as per your direction in that case of Keonjhar, we have already started a special drive. We have first identified there are 62 such cases starting from 2000 onward where this furlough jumping has taken place, and we have given direction to all the concerned superintendent to file FIR in the first place and then carry that document to district SP as well as the concerned police station to get them apprehended at the quickest possible. So already, I think one person have been arrested. Two persons have been arrested in that drive, special drive. We are on the job, sir. We are doing a special drive to get them back. And as far as jumping of furlough is concerned, sir, Amar sir, jail ru regularly there is a procedure for which a laid down procedure. जोटी district magistrate एवं SP कर first आगो recommendation आसीबो through superintendent of police से ताको superintendent of jail ताको पठेबे तार conduct देखा जिवो तापरे ताको allow करा जाउची थरे जे jump कला किंबा mischief किछि कला ताको future आ दिया जाय नै एबेले अलगा penal provision अछि तार जेतेबेले premature release हबो सेतेबेले भी ताको सेटाको गोटे नेगेटिव ब्लैक मार्क भाबरे देखा जाय ए सब तारो प्रिवेंटिव मेजर्स अछि तो आमर सर 100 संख्या रे प्रत्येक दिन प्रत्येक मास रे जाउचंती फरलो रे वी हैव अराउंड 18000 इनमेट्स तो एमती स्ट्रे इंसिडेंट किछि होउची बट मोस्ट ऑफ देम रेगुलरली कम बैक इन टाइम सर हम जो स्ट्रे इंसिडेंट गुडा आगुरो ओवरलुक हे रहि जाइची सर जोता पॉइंट आउट करचंती ऑलरेडी केउंजर केस रे ऑलरेडी हमें वी आर on a special drive, sir. We are hopeful that we will get them back.
Okay. So just let us, here I'm passing the order. Let me do. The DG of Prisons Mr. Fonso, on being informed by us, we asked the London State Council to ensure the appearance of DG of Prisons to virtual mode, and accordingly, he appeared. And we apprised him about the inordinate delay occasioned in this case in filing the jail criminal appeal by the appellant, who is a life convict. He stated that coming to know about this sort of problem, a special drive was carried out in the month of July. Na kebe kahile apono?
Exact date one नहीं सर सर को मु डिस्कशन करी के आस्थिली सर मते
कोई स्पेशल ड्राइव carried out and केतेटा आइडेंटिफाई अपन करथिले कुचंती प्राय 150
सर एग्जैक्ट नंबर टा मोपे के नहीं जस्ट क्लर्क अबे नहीं more than
100 cases were detected where the criminal appeals or jail criminal appeal numbers were not available with the jail authorities. Accordingly, arrangements were made to prefer the jail criminal appeals. In those cases, you prefer jail criminal appeals. Steps have been
Yes.
taken to prefer the jail criminal appeals.
One of them.
And the present case is one of them. Stop. He has assured this court that the track record of all the appeals which are being filed by the convicts, either by their own arrangement or through legal aid, the case numbers, the name of the counsel, the contact number of the counsel, the status of the prima application, including the bail filed in the appeal, should be would be maintained, and a sheet of paper shall be provided to the respective convicts containing all the data. Stop. If any convict who is detained in custody and states before the jail authority that he has made his own arrangement to file the criminal appeal, the number of such appeal and the name of the counsel, his contact number, shall be ascertained, verified, and records thereof to be kept for future reference. The correctness of the filing of the regular criminal appeals by a convict can be verified through the High Court website if the appeal is to be filed before this court. The DG of Prisons has assured this court that he will make another special drive in different jails of the state where convicts are detained to know whether they have filed the appeal challenging their conviction or not, and whether the appeal numbers, contact number of the counsel are available with the jail authority or not. And in case it is found that any convict had not preferred any appeal, immediate steps shall be taken for filing the appeals before the appropriate court with the help of the DLSA secretary, so that delay can be avoided and it would facilitate early disposal of the appeal and passing order on the interim application. The data collected by the DG of Prisons jail-wise shall be submitted to this court within 4 weeks. Sometimes the convicts sometimes the convicts are unaware of their legal rights or appeal processes, and sometimes they express unwillingness and are reluctant to file appeals for various reasons. If any convict does not choose to prefer appeal against his conviction in spite of proper guidance and advice, being aware of his fundamental and statutory right, the same will be obtained in writing from him by the Secretary of the District Legal Services Authority, and same shall be forwarded to the member Secretary of Odisha State Legal Services Authority for future reference, and a copy of the same shall also be kept with the jail authorities. The convicts should be guided properly and provided suitable advice regarding their statutory and constitutional right to prefer the appeals, and if necessary by taking the help of their family members so that appeals can be instituted with their consent. The Honorable Supreme Court recently held in case of so and so that the appeal filed without the convict's consent amounted to misuse of process of law. Therefore, it is necessary that the convict's refusal to give his consent to prefer an appeal should be obtained in writing. Stop. Since the legal system provides a robust right to appeal, the convicts who are unable to make their own arrangement in preferring the appeals against conviction should receive free and effective legal aid as part of their right to access justice. During course of this hearing, it is brought to the notice of this court by the Learned Counsel for the state by producing the reports from the prison welfare officer Biju Patnaik Open Air Ashram, Jamujari, that some of the convicts
17 escaped
who were on furlough, oblique parole, or special leave have not surrendered after expiry of such period, and some of them have also absconded from the open air Jamujari jail. The DG of Prisons has stated that he has been informed that about how many cases you found out, Mr. 62 cases. More.
Unmute, please.
Please unmute yourself. More than 60 cases you found.
62 cases, sir. 62.
We are not able to hear you again.
62 cases, sir.
Okay. Submit that 62 cases have been detected where the convicts, after expiry of the furlough, parole, or special leave, have not surrendered, and it has been instructed to the concerned jail superintendent to file FIR before the concerned police station, and steps are being taken to apprehend them, and in case of such convicts who have flouted the terms of the furlough, parole, or special leave, in future they will not be granted any such leave. Stop.
And it will be used as a black mark in premature release.
And it would be also used as a black mark for their premature release. Stop. A free copy of the order be handed over to the Land and Council for the state, which will be forwarded to the DG of Prisons. A copy of the order be forwarded to all the district and session judges with the approval of the Honorable Chief Justice. Stop. The personal appearance of DG of Prisons and jail superintendents want so. The Secretary DLSA is dispensed with. Stop. After main jail criminal appeal to pade asun. Considering the poor financial condition, delay is one so. Considering the poor financial condition of the appellant, the period of detention in judicial custody, and the circumstances under which the jail criminal appeal could not be filed earlier, and since the appellant has been sentenced to life imprisonment, taking a liberal view, we are inclined to condone the delay in filing the JCRLA. Accordingly, delay is condoned. Third, admit call for the trial court record. The file be placed before the Land and Registered Judicial during course of the day, so that a copy of the order shall be sent for opening the trial court record. And after the receipt of the trial court record, steps shall be taken for immediate preparation of the paper book by 12th of December 2025. Mr. Gautam Mishra, Land Senior Advocate, is engaged as the amicus curiae for the appellant, and copy of the paper book shall be supplied to him, so also to the Land Council for the state, and matter will be listed on 26 मसीहा कैलेंडर में 7th रख दो. On 7th January 2026 for hearing. Stop. If the Land Senior Advocates want to interact with the appellant to know about the case matters, the arrangements shall be made by the Stop. Madam, we are sending today the order copy, and you make necessary arrangement to send the digital copy so that the paper book can be prepared at an earliest. We are fixing the time limit for the preparation of the paper book, so also the hearing of the case, since 12-13 years have passed unnecessarily and appeal could not be filed. Right?
Yes.
And we have engaged a senior advocate for him to argue the criminal appeal, and the appeal will be taken up for hearing in January. January 7th. 7th it will be. Acha,
सर जस्ट टिके हमर सर टिके हम तरफ टिके भूल फिगर हे गेला सर सेटा 62 नहीं 66 हो सर 62 नहीं
66
66
okay 66 and that number are you having that अपन जो पाइले जो केसेटा केस रे अपील फाइल
सर सेटा नंबर मिलला सर सेटा सर 23/5/2025 आमे स्पेशल ड्राइव करके देइछु
हाँ तार नंबर टा कौन
सेथिरे सर तीनटा कैटेगरी दिया है सर 2715 कन्विक्ट्स जो मानकर अपील फाइल हेकरी ऑर्डर हे जाइछि रिफ्लेक्टेड एंड पेंडिंग और डिसमिस भी हे जाइछि 134 कन्विक्ट्स जो मानकर अगेंस्ट रे अपील नंबर हम पाखरे अवेलेबल अछि रिजल्ट हम पाखरे अवेलेबल नथिला दैट वाज एनेक्सर बी आउ 301 केस रे अपील नंबर ही नथिला तेणु से माने अपील फाइल करछथि कि नै जणा नथिला आमे ए चिट्ठी सर 8016 लेटर नंबर आमे पठिथिलु 19/5/2025 रे सेक्रेटरी हाई कोर्ट लीगल सर्विस कमिटी को एवं तांकठरो हम पाखु कंफर्मेशन आसी पहुंचिला सर 18/8 रे that we have received and we are working on this we have received
can you please send that letter once again so for so that we can incorporate in the order just
Sir.
send it upon arrangement करूँ तो immediately चाहिए
WhatsApp पर नहीं print out
हाँ WhatsApp पे नहीं print out कर
हाँ सर
अच्छा ये anything further you want to say Mr. DG of Prisons anything further
no sir we are working on it sir we are working on many other things sir I will come to sir again bring other things
but you do one thing in the sometimes you also have an interaction with all the jail superintendent virtual mode and apprise them about all these things so that thing can improve, the situation can improve. So,
sir every week we are having a VC with all the students on various aspects and then we discuss all these issues including so many security and welfare and other issues and we'll also discuss this issue.
Okay अच्छा जटिया हेम्ब्रम सेटा अनम्यूट करो सेठी जेल अनम्यूट जटिया हेम्ब्रम तमे सुनी पारुचो हमें जहा कहूचु हां तमे ए जो तमरो जो आजीवन कारादंड हेइथिला सेटारे तमको जो वकील को कहिलो जे अपील पाई दायित्व देइथिलो तमे तो जानिलो जे अपील फाइल हेलानी बेली तेणु वर्तमान तमर ए जेल रु अपील फाइल हेइची एवं ता धेरे जो समय भितर फाइल हवा कथा जेहेतु सेटा से समय भितर हेई नथिला बहुत विलंब पाखापाखि 12 वर्ष उपरे विलंब हेइची तेणु से जो विलंबटा को आमे क्षमा कर देइचु एवं तम अपील टा वर्तमान विचार पई ग्रहण हला आ तळ कोर्ट रेकॉर्ड टा वर्तमान आसीबो तार आसिला परे हाई कोर्ट रे गोटे वही तैयारी हुए पेपर बुक केस रो विचार पई सेटा तैयारी हबो एवं तम केस रे जणे सीनियर एडवोकेट गौतम मिश्र को आमे तांकू एंगेज कलु जेहेतु विलंब ऑलरेडी हेई जाइछि एवं तमर केस जनवरी मास 7 तारिख दिन हला जनवरी मास 7 तारिख दिन सुनानी पई उठिबो हला तो ए इन्फॉर्मेशन आमे जानिलु एवं ए आर आजिरो जहा ऑर्डर हला अपन पाखु पळेइबो मध्ये सरकारी वकील पठेई देबे जेल सुपरिटेंडेंट को सी बाकी सब जिंस अपन को बुझेई देबे ठीक अछि अच्छा सेटा टिके आनिकिन देइबो
copy of the order to Gautam Acharya. This
I went to Gautam Mishra हम गोटे कॉपी दे देबे ऑर्डर तो कॉपी है बाकी ठीक अछि अपन माने ये करू हां now come to the next one
Item number 3.
Yes, item number 3.
The well-being was called for, that report has come. Kumbani Setish, appellant number 1. କମଳା କେତେ ଧମଳା କମଳା ସେଟା applicant number 2, ପ୍ରତିମା ସେଠି applicant number 3, and Tinnath is applicant number 5. Antonu next one below the applicant number 4.
So they are all alike. ଦେଖନ୍ତୁ as for the order dated (17/10/2025), the Land Council for the state has produced the written instruction received from Inspector in charge, Talsinghi Police Station, Ranjan, that all the 5 appellants are alive. The written instruction is from the court. Is where is the council? ପ୍ରତିଭା ମିଶ୍ରଙ୍କୁ କୁହାଯାଇଥିଲା ପ୍ରତିଭା ମିଶ୍ରଙ୍କୁ ଫାଇଲ କରିଥିଲେ वकालतनामा, but that is in 2007. प्रतिभा मिश्रा, प्रशांत कुमार Mishra, Miss Sarmishta Kuntia, and Manas Ranjan Das. They are the 4 council. এটা 2007 ତାଙ୍କର ଅଛି 2009 ରେ ଆପଣ ଆଜି ଗୋପାଳ କୃଷ୍ଣ ନାୟକଙ୍କ ନାଁ
subsequent perhaps.
ହଁ ତ ଗୋପାଳ କୃଷ୍ଣ ନାୟକଙ୍କ ନାଁ ମଧ୍ୟ ଅଛି ତ ଏଠି। So why don't you intimate him? ହେଲା are you having the number? So just give a call so that he can come. Gopal is appearing for Unami only.
Only Gopal Krishna one that 2009 it has filed.
No, he has filed all the
1/5/2009.
almost not has you. दो तीन से हाँ one out of the चार्ट आज चार्ट तो फास्ट आ जाएगा है ना no objection नहीं हाँ no objection नहीं no don't feel अपन तो आपके लोग इधर लाकेस्ट है ना ये जब नॉर होता है करो उसी साथ ना तो देखो since Mr. Gopal Krishna Nayak has filed वकालतनामा for all the appellants. The names of Srimati Pratibha Mishra, P.K. Mishra, Miss S. Kuntia, and Mr. M.R. Das shall not be reflected in the clause list henceforth. এটা আসলে কহিবে আপন next week
Next week
okay আসবে যদি আচ্ছা the we are writing that
already intimated.
Is he coming? যদি আসবে তো because these are 2007 matter, it can be taken off. Paper book is ready, you can, if he has got the paper book, it's well and good, and you can
Will also receive allowed to this paper.
no, that's all right. You have not received the paper. Okay. So let him come. Huh? Next case.
Item number 4.
For that Jamajori report has come.
ସେ ଜାମୁଜର ରିପୋର୍ଟଟା ନେଇଗଲା ତାର କପି ଅଛି କି? Fifteen of them.
17 escaped ହେଲେ 15 ହଉଛନ୍ତି ଯୋଉଟା bail. Out of them one has died. That Keunjhar last week he was produced, other accused was produced. And one person was a premature proposal was sent but not considered pending. And in another case,
Listen, in pursuance of the order dated 27/10/2025, the Land Council for the State has produced written instruction which contains the detailed list of the convicts who have escaped absconded from Biju Patnaik, Open Air Ashram, Jamujari.
serial number 9 has been recaptured in the meantime.
And it contains the list of 17 persons.
And 9 has recaptured, 10 has modified appeal, their sentence modified.
No, এই কেসের কোন এই যে লোকটার আর কোন
ধরা হয়নি।
আচ্ছা তারপরে লিখুন another list indicate that 15 convicts have not surrendered after expiry of the FOLNO parole special leave period in respect of the Biju Patnaik Open Air Ashram, Jamujari. The reports are taken on record. So far as the appellant Munsi Bue alias Mansi Bue is concerned, that number
serial number 12 in absconded, escaped absconded.
It is mentioned that several correspondence have been made to the concerned IIC to recapture him.
Serial number 9 has recaptured in the meantime.
No, we are case to case basis. So what we wish to do, we cannot keep this matter pending. We will decide the matter, and suppose the result of the appeal so desires, so he will be captured and and if let us say an acquittal order is passed, then matter is otherwise. But for that we cannot. So You have received the paperwork. Get the paperwork, Mr. Who is to argue the matter? Mr. So you get the paperwork and paperwork theory, and you have received the paperwork. No. The Land and Council for the appellant, so also the Land and Council for the state submit that they have not received the paperwork. Let copy of the paperwork be supplied to the Land Council for the respective parties during course of the day. Aji in huya. है ना? Matter will be stayed on 8th of December 2025 for hearing. Yes, next.
And number 5.
Give the wakalatnama so that it a fill up for the as per the order dated 10/11. Can it be filed in that?
I'll file it along with the bail application.
As per the order dated 10/11/2025, the Land Council for the state has obtained the wakalatnama signed by the appellant from the jail, and it is handed over to Mr. S. Saurav in court. So submitted that he will fill it off and file stop the wakalatnama filed is kept on record. Stop. The moment you file the interim application, make a mention so that it can be gathered.
May I pray for a copy of the TCR? It is there.
The trial court record. Acha, you paper book is available now. Have you not received the paper book? No. Acha, are you? No. Acha, let me. Since the paper book has been a paper book theory, a copy of the paper book be supplied to the Land Council for the appellant, so also to the Land Council for the state. Yes.
At number 6.
Section 364 and 30.
Where is Mr. Satyanarayan Jana?
The report regarding the custody certificate as well as the jail card.
But somebody has to move the bail application. Last time he appeared.
Yeah, so then as per the direction, we file bail application as well as the IA for stay
What is he now? ଜାଣିଛନ୍ତି ଯଦି ଟିକେ ଫୋନ କରନ୍ତୁ ସତ୍ୟନାରାୟଣ ଜେନା. These are all jail criminal appeals and they have a responsibility to attend the court, and these are all old matters. They have been engaged. Okay, next matter, Doctor.
At number 7.
Yes, Mr. Soro.
Yes, sir. Kindly see the last order.
So, anything?
Yes.
Please.
The meanwhile, there's no criminal incident except this. In the meanwhile, 2005 was one of the eyewitnesses got married. Already. Already.
What about the custody period?
The custody certificate is on record.
Acha, it is already on that.
7 years.
One eyewitness.
PW5.
4, 5, 6, all are eyewitnesses.
Lord, they have turned hostile in the deposition and the cross. Only PW5 remains constant.
You should kindly see the 313 statement, question number 1 and 13.
What is that? Active statement. 1 and 13.
Question number 1 and question number 13.
It appears from the evidence of PW4 informant. 6, mother of the informant. That on essentially big money from your father. When you deny it, you be your father by means of an act. Acha, it's a case of patricide.
Your Lordship.
You sustain, your father sustains ransom. ବାପା ମତେ ଘରୁ ବାହାର କରିଦେବା କଥା କହିବାରୁ ମୁଁ ତମ ହାଣି ଦେଇଛି ବାକି ଆଉ ଗୁଡା କଥା 30
question number 30 so same
ଆଚ୍ଛା ମତେ ବାପା କହିଲେ ଘରୁ ବାହାର ଯା କହିବାରୁ ମୁଁ ରାଗିକି ବାପା ଯେତେବେଳେ ବାପା ମେଡିକାଲରେ ମରିଗଲେ ଆଚ୍ଛା ଏଇ ଯୋଉ 3 ଜଣ ସାକ୍ଷୀ ଦେଇଥିଲେ ଆଇ ୱିଟନେସ୍ 4, 5, 6
yes
how they are related to
family members one is wife another is son and daughter
nahi
PW4 informant is the brother of the appellant. PW5 is the sister of the appellant. PW6 is the mother of the appellant.
So, how do you say that they have not supported the prosecution case?
Please see
4 and 6.
My lord, may kindly have my lord page number para 4 of cross of PW4.
No, I have not seen the occurrence.
Yes, similarly, a lot of people say PW6.
Just a minute.
PW6 cross para 3.
PW6 paragraph
para 3.
Para 3. I had not seen when my son so but I heard also. And 5 into coach.
My lord, PW5 from my lord, there is no cross, my lord. It is not a fact. Your lordship on the last occasion was also had also seen.
What is this thing? Wow. You see, this defense counsel, state defense counsel are engaged.
Not sure.
And 302 case is the type of procedure. What can be done here? Magistrate trial case रे भी ताटू अधिका जेरा करछन आई विटनेस को दीटा सजेशन दे छाड़ दी
Defense counsel will not be there, that's better. Defense counsel block the better. With quality of defense counsel were engaged, that's the law.
There are state defense counsel too.
Yes, your lordship.
Remand no kole material को कौन करेगा confirm नहीं है Mr. Saurabh,
Your Lordship.
you find out decision if a state defense counsel, there are a number of cases, if cross-examination has not been done, then this court has, even in death reference case also, they have set aside the
Remanded back for
and remitted back the matter to allow the for face engagement of a senior counsel to cross-examine it and that witness, and thereafter this argument is to be advanced and the judgment is to be rewritten. କାରଣ ଏଠି ଆମର ଚାରି ପାଞ୍ଚ ଛଅ ଯଦି ତିନିଟା ଆଇ ୱିଟନେସ୍ ହେଲେ ଚାରି ଛଅଟାକୁ ଯଦି ଡିସବିଲିଭ୍ ହେଇଗଲା on this now ବାକି ରହିଲା ପାଞ୍ଚ and ତାର cross examination ଯଦି ହେଇଛି କିଛି ବାହାରି ଆସିଲା so the result may otherwise.
Subject to 313. Subject to 313.
No, this justice has not been done in this case. You see, properly, and at this time of recording of the accused statement also, the counsel must not have present. ଛାଡ଼ିଦେଲା ନା ସିଏ ତାର ତାକୁ ଇଏ କରିଦେଇ ନହେଲେ ଗାଇଡ୍ କରାଯାଏ ଯେ ତମେ ଏ କଥା କହିବ ଏମିତି ଏଇ କ୍ୱେଶ୍ଚିନ୍ ପଚାରିଲେ ଆଣ୍ଟିସିପେଟ୍ କରାଯାଏ ଏକ ନମ୍ବର ସାକ୍ଷୀ ଉପରେ ସେ ଏଇଆ ପଚାରିବେ ତମେ ଏଇଆ କହିବ ତ
On the question number 1 only he agrees to the.
no, this is the to find out those decisions. We can take up this matter next week.
Yes, ma'am.
And it is paper book has already been prepared. Why we should go to the bail aspect and finally dispose of the case. Have you received the paper book?
Yes, Lord, I have the documents.
Paper book copy supply for them. The you have also not received the paper book. You have received it. Asha, the land item number 7 JCRL number 67 of 2019. The Land Council for the state has produced the report on the criminal antecedent of the appellant. So also the instruction that PW5 has got married in the meantime. From the reports have been obtained from IAC Jarpada police station. The reports are taken on record. Mr. Saurabh, Land Council for the appellant submits that if he since the paper book has already been prepared, he may be supplied with a copy of the same so that he will argue the matter finally next week. Land Council for the state has received the paper book for him. The matter will be listed on 3rd of December 2020. In तारीख आसियो এই order setting রে আসবে আমি এটা dispose of করব.
Yes.
Grateful. Yes, next.
Number 8.
We are Mr. Gujamila praying for Arjun.
What is the offense here?
P02.
P02.
And
how many years?
20. The custody report is recorded. Custody and conduct report is on record.
Custody का कितने? 8 years. 8 years to month. The mention is made on behalf of Mr. Arun Kumar Vidya for Arjun. Upon बाकी से नहीं आश्चर्य तो
all the reports are on record. Custody certificate, criminal antecedent and conduct. All are.
And you have got the deposition copies with you.
I've got the deposition.
Don't take adjournment. This jail criminal appeal doesn't look nice. It's not a private brief. See this. Yes, next.
Act number 9.
May
Public after the slow. After Maru the exception.
May please. Appellant convicted under section 302, sentenced to undergo arrest for life.
Yes.
Nursery
1 minute is.
custody since 18
Yes, madam.
2016. 9 years, 10 months.
Nine years, 11 months, as on 17/11/20.
No criminal antecedent.
No.
What is the case here?
This is the mother of the appellant.
Oh.
Should kindly say the evidence. PW9 is the medical officer.
No, eyewitness is something.
1, 2, and
1, 2, 3, the eyewitness. Who is that eyewitness?
1, 2, and
14.
our
14 is the informant.
PM.
PW9.
Good is eyewitness पढ़ूँ
It starts with 1.
1. No?
The relevant question
One.
starts from paragraph.
1, let's see.
Mm-hmm.
1. I know the informant. I also
Relevant
know
part.
relevant part. Paragraph 3. On the date of incident, the accused came with the intoxicated condition and the oil of the Udaya Gowda, for which Udaya Gowda abused the accused. Then the accused entered into his house and picked up a quarrel with his mother, deceased. The accused also abused his deceased mother and threw her outside of his house. At that time, one Hari Paricha, a neighbor of the accused, protested the accused and told the accused to take his deceased mother inside the house. Thereafter, the accused took her mother inside his house and assaulted her deceased by means of a Katho wooden plank, and the accused also assaulted her deceased mother by means of iron rod. The deceased shouted as a Bupama, then deceased died there. Let's see the Katho and iron rod. The IO evidence and that has not been produced before the court. Another thing, the doctor evidence.
PW1, 140. They say he was regularly assaulting his mother, and one finding is proof factor. Kindly see the PW9.
10 वर्ष complete करनी था
No. 9 or 11.
9.
तब रखी जाऊँ तो February बरोबर. The Land Council for the state has produced the certificate, so also the report on the criminal antecedent of the appellant from IAC Tarsing Police Station. Our state superintendent, both are released this matter in February 2027. अच्छा jail conduct can be achieved.
Yeah, custody certificate in column number 7 stated that jail's conduct is satisfactory. Kindly see the column number 7.
Column number
7.
in the conduct certificate, custody certificate in column number 7.
Separately.
It has been mentioned that the jail conduct is satisfactory. Yes.
Item number 10.
Item number 10, the next has called for a report from the jail regarding the custody as well as the PA and control. He has one criminal entity apart from the present case.
The offense there.
341, 294, 323, 506, 30.
Total period.
2545 days.
So 7 years later.
Near about 6 years, 11 months. Near about 6 years, 11 months.
6 years, 9 years.
Involved in 2 cases.
What is the case?
My lord, the allegation is that the appellant killed his wife, and the informant is the husband of the deceased. Informant is the husband of the deceased, and the deceased has a live-in relationship with the appellant. And the dead body is found inside the premises of the appellant.
Eyewitness?
There is no eyewitness.
There are
Based
witness
upon
to the
certain
assault of the
circumstantial
there are
evidence.
witness to the assault on the deceased.
No, what are the circumstances if there are no eyewitnesses?
PW7 said the deceased was staying with the accused. PW8 is the PM doctor who describes all the injuries found on the person of the deceased. PW10, he has seen the quarrel between the deceased and the accused. PW2 and 1, they have seen the appellant assaulting the deceased. Immediately thereafter, she was found dead. PW1 and 2.
Where the dead body was found?
It was found in the house of the appellant.
As per page
PW1.
58, page 58, on the deposition of witness of 6, that the dead body is found in the veranda. That's outside the premises of the house.
I'll place PW1 and 2 for a minute.
Yes.
PW1, I'll place paragraph number 2. The occurrence took place 2 years back on 16 December. On the occurrence date, there was altercation between the accused and the deceased. My mother attempted to subside the matter, and on my call, she did not interfere, and we both left away from the occurrence place and we went to our new house. The house of the accused situated near our old house. Thereafter, you'll have to paragraph 5 and 6. The deceased has been staying with the accused 2 to 3 years prior to her death after leaving my house. I have not yet married to another lady, and I am staying with my daughter. On the occurrence date, I had gone to our old house with my mother. My mother protested the accused not to abuse the deceased in filthy languages and tried to intervene when the accused was beating the deceased. I had not seen accused assaulting the deceased by means of a steel pipe. However, I mentioned in the affair circumstances. Thereafter, PW2. Paragraph 2. The occurrence took place 2 years back on 6th December in the night about 9 p.m. I came to know about occurrence when the accused Sukaram was saying Morigala, Morigala. Next day morning, I came to the spot after arrival of the police and then informed the matter to the informant. Police examined first. Paragraph 3 would be relevant. The house of the accused situated at audible distance from my house. On the occurrence night, I heard the accused crying, Mari Deliku, Morigala, Kuni Morigala, Mo Ghara Ujudigala. At that time, I was present in my house. The father of the accused came to my house and requested me to make a phone call for ambulance and informed that his daughter-in-law was in serious condition. I asked him as to what happened to Kuni. He replied Sukaram had killed Kuni. I told him to inform the matter to the vicinity official. Therefore, you have to come. With the police separate.
So, from the evidence, it appears that the deceased was staying with you, and the dead body was also found. Somebody says that it is in your courtyard, and
Yes.
some says it is in your house. Whatever it may be, but the death is homicidal.
Yeah.
Uh,
PWP says I saw Kunila lying dead in the courtyard that Ogona house of the accused. PWP says that film number 4 that I saw the dead body of Kunila lying in the bedroom in a full plot.
You remain for some more time. We are not rejecting, keeping and February because your remain only 6 years now. Let 7 years be completed. February will be. You would have take up for the এটা হচ্ছে criminal antecedent report custody ଆଉ ଗୋଟେ ହଉଛି custody certificate ଆଉ ଗୋଟେ କଣଟା ଦେଇଛନ୍ତି jail certificate.
I'm sitting on matter 32, madam. Medical issue. 32. Yes. Last order में kind है. This honorable court directed me, madam, to seek some time regarding availability of the medical document and to file the same. I have already filed, your lordship. This is a paid copy and also served to the London State.
Take instruction on those medical. IA number, this is 32, CRLN number 1171 of 2023, IA number 2650 of 2025. Is an application for interim bail on the ground of element of the father of the appellant petitioner. As for the order dated 27/10/2025, the Land Council for the petitioner has filed the medical documents today in court and also handed over the copies.
Already filed.
Thereof. Already filed.
Filed, madam. That is not on record yet.
But that has been tagged to record.
Not record, tagged.
Submit that he has already filed the medical documents. Let the same be placed on record. Copy of the medical documents have been handed over to the Land Council for the state to seek some time to obtain instruction on the interim application. Please this matter. What's the real opinion?
Only one plate, my lord. The father of the appellant, my lord, is staying under the jurisdiction of Alto Porburim Police Station of North Goa. Alto Porburim Police Station of North Goa. North Goa.
Then verify. What happened over the item number, Mr. 33, item 049?
I contacted what online
we are listing, he is not there. Whether he is there.
After a religion of bail, the appellant had no contact with me, my lord. After religion of bail, the appellant has no contact with me, my lord.
Jail criminal,
Jail criminal, the appellant has engaged me, my lord. The appellant has engaged me, my lord.
He privately engaged her?
Yes, my lord. Yes, my lord.
So what about whether he's alive?
They have no contact after religion of bail, my lord.
Just a minute.
Give the report. All of them are alive.
ଏଇଥିରେ ଆଚ୍ଛା ଆଚ୍ଛା ଇଏ ମିଷ୍ଟର ନାୟକ ତାଙ୍କୁ ଆମେ ଡାକି ଦେଇଥିଲୁ ଏଇ ସେ 5 ଜଣ ଯୋଉ ଅଛନ୍ତି ତ ନା ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ all of them are alive. Mr. Nayak,
Yes, my lord.
you get the paperwork and argue the case.
Yes, my lord. I will argue the matter, my lord.
ସେ alive ଅଛନ୍ତି ଆପଣ ବାକି ଜିନିଷ ସବୁ ଆପଣ ବୁଝାବୁଝି ହେବେ ନା ଆପଣ ଅପେକ୍ଷା କରିବୁ ନା so they are alive and you argue the matter. Order ହେଇଯାଇଛି. You receive the paperwork.
I will argue the matter. Let it go next week, my lord.
Have you collected the paperwork?
I will
Mr.
verify.
Nayak.
I will verify when the.
ଆଚ୍ଛା ଆପଣ ପାଖରେ ପେପରବୁକ୍ ଅଛି ଆଚ୍ଛା ଏଇ ଯୋଉ ଆଇଟମ ନମ୍ବର 3 ରେ ଅର୍ଡର କିଛି ଦରକାର ହେଇଥିଲା ତାପରେ ଲେଖିବେ ଯିଏ ବି ନେଇଥିଲା ଡିକ୍ଲେରେସନ ମିଷ୍ଟର ଗୋପାଳ କୃଷ୍ଣ ନାୟକ submits that he will argue the matter next week. Yes, this matter date be 10 तारीख है ना for hearing କରିବେ ଆଉ ଯଦି ପେପରବୁକ୍ ନେଇ ନଥିବେ ନା ଦେଇଦେବ ତାହେଲେ କପି ଦେଇଦେବ ଗୋଟେ ପେପରବୁକ୍ ଷ୍ଟେଟ୍ କୁ ବି ଦେଇଦେବ 3/12/2025 ତାକୁ ନେଇକି ଆସିକି ଶୁକ୍ରବାର ଦିନ
item 45 minus. Item 45. Only surrender report or business person 45 months.
Report is been sought.
Well, surrender report and
you see ସେମିତି ବର୍ତ୍ତମାନ ବାହାର କରିପାରିବେନି ଯୋଉ ମ୍ୟାଟର ରହିଗଲା ସେଟା ସିରିଏଲି କରି ନେଇ ଆସୁଛି ଏଗୁଡା ଲେଫ୍ଟ ଓଭର ହେଇକିରି ଆସୁଥିଲା ପରେ ଲେଫ୍ଟ ନାଇଁ ଗତ ଥର ଆସିଥିଲା ପରେ
Left over.
ଲେଫ୍ଟ ଓଭର
ଆଜି ବି ଲେଫ୍ଟ ଓଭର ଆସିଛି
ଏଗୁଡା ବି ଲେଫ୍ଟ ଓଭର ସେଟା ଆସିଛି ଆଉ ସବୁ ଲେଫ୍ଟ ଓଭର
ଯେତିକି କହିଥିଲେ ତାପରେ ସବୁ ଆସିଲା ଆଜି ଆସିଛି
ବହୁତ ଜିନିଷ ଲିଷ୍ଟ କଟି ଯାଇଥିଲା ଫେର ଆଜି ଲେଫ୍ଟ ଓଭର